from the court 14.
Your son got hurt yesterday. Your son got hurt yesterday.
My nephew.
He's okay.
He's okay.
Yes.
You're also president of 513 from the court 14.
Yes. What is
I'm saying that this may be taken up today or tomorrow.
What is the urgency?
Urgency is that they're not getting the proper salary. And we'll just argue the point notice to the Russian Honorable Chancellor. Vice Chancellor. But this is the
from the list of content matter.
Content. How
Yes,
do I?
only the issue is
What you see, I cannot decide the content.
only it is fresh finding content. You will notice maybe
No.
only the urgency.
In content, notice is not automatic.
The urgency, if I may. Lordship, the retirement date of the petitioner would come in the month of August. And he had preferred a verdict, issue 1, against which the department went for LPA, which got rejected. And in this period, Lordship 5 years advanced, Lordship. And now he would be retiring
When?
in 2 or 3 months, Lordship. And if yes,
yes, now you see, you will have the judge very soon. You will be back very soon. Already 2 weeks has elapsed, right?
One matter, second again. It was 2007. It was dismissed for default. Then we filed a situation, it was dismissed on final notice. We went up to the Supreme Court. Supreme Court has directed to restore the matter to its original file, subject to the condition that we pay 25,000 to the respondent.
25,000 to
The respondent as a question. When the respondent is not taking the draft, it is the outside. So, last year 4 months he persuaded the office to put before their report.
No, but it will not come to me.
They are not putting before the report. They do not understand that how the draft shall be received by the respondent. They are working on
Just a
that.
moment. I don't have the second appeal roster as of now.
My lord,
I don't have the second appeal roster.
second appeal.
Roster. That roster is not there with me now. आपको नहीं पता second appeal का?
Second appeal lordship.
यहाँ पे सिर्फ assigned matters, second appeal बहुत सारे matters.
Sorry.
दूसरे के यहाँ से recusal matters. है ना?
Outside is from both working, one transfer matter.
Tomorrow.
From the daily court list and reading for fresh filing, item 1, ABA 4003 of 2026.
Senior counsel is appealing to workload mode. Just please see that.
What's his name?
Mr. Rai.
Mr.
Just please see the Rai.
Can you hear me?
Yes, leadership, I can hear you.
Yeah, I'm sorry for being late. I have not been keeping well for quite some time.
Oh, no one is getting. I hope now leadership is fine.
Yeah, yes, I'm fine, but some issues were there. I kept you waiting for so long.
No, it's my duty.
Yes,
This was an anticipatory bail which has been filed by the applicant where he has been already charge sheeted and in entire investigation he has cooperated and he was never arrested by the police because he was cooperating all through. That has come in their charge sheet as well. That all through he was cooperating and 4 more persons I got to know who are also accused in the same RC, which is leadership Parveen Kumar Budia, Shiv Prakash Singh, Prem Kumar Chaudhary and Dharmendra Chadha. All 4 of them have been granted bail by this honorable court. Now, the entire
we will
equipment,
call for a counter affidavit.
leadership,
We'll call for a counter affidavit.
leadership can call, otherwise it's a very limited issue.
Okay.
Because now CBI never arrested, rather
You intend to
CBI
file any
said,
counter affidavit?
Lordship, the charge sheet is also not there, CBI charge sheet.
They are insisting on filing out a counter affidavit. How much time do you need?
At least Lordship, 3 weeks, at least 3 weeks, because it has to be approved by the authorities, takes time.
Alright. They have been cooperating throughout.
Yes.
Is it a fact? Is it a fact?
Page 169 says so, their own charge sheet.
That instruction I will see. Because that is the summation, Lordship.
This is the charge sheet of CBI?
Yes,
CBI, this is, there was a.
in extra 44.
Yes.
Sorry,
Just.
Lordship, there was already a vigilance case, Lordship, by the state, Lordship. Thereafter,
This
there was order of
National
report.
Games issue, we all know.
We have filed the charge sheet on behalf of the CBI, Lordship, and thereafter, Lordship, the cognizance. So there is a separate charge sheet on behalf of the CBI, Lordship. We are not relying on the charge sheet of that vigilance. We have a separate charge sheet in which the accused has been charged. So that is not.
Which page are you referring that you have been cooperating?
It starts from page 160, page 169. My lady.
169 is your document?
Yes, sir, it's a charge sheet.
Yes.
Correct.
Don't be
Their document,
simultaneous.
not my document.
169.
169, second, last paragraph, middle. निर्गत नोटिस के आलोक में तीनों कंपनी के ओनर प्रतिनिधि पूछताछ हेतु उपस्थित हुए तथा इनके पूर्व भी समय समय पर पूछताछ हेतु बुलाए जाने पर समय पर उपस्थित होते आए हैं तथा अपने बयान में सभी बिंदुओं का पूर्ण है बुलाने पर.
Yes, I've seen that.
Page 160, Lordship. This is the charge sheet. This is the final form of the vigilance, Lordship.
Vigilance.
Not the
This is
CBI.
not
Lordship.
the CBI. This is not a part of CBI
Because
charge
in
sheet.
our case it will be RC. It's not a RC charge sheet.
This is
No, Lordship,
this is
even
something
in-
which is reflected regarding the vigilance inquiry or the vigilance proceedings by the state. Not is there anything mentioned so in CBI charge sheet?
This is the difficulty is the CBI charge sheet perhaps I'm being told is not being received by us yet.
So
But-
CBI charge sheet is not there on that.
But they have now leadership, they have filed the charge sheet without even arresting me. All through. Otherwise they would have arrested me.
So they are very
Meaning
kind to
thereby their investigation qua me is complete. And unless I cooperate, they cannot file a charge sheet against me.
investigation must be still on.
No, investigation
No,
has been completed.
it's
Lordship.
complete.
Cognizance has been taken, Lordship. This man happens to be resident of Delhi.
Yes.
And therefore, Lordship, I was saying, Lordship, the charge sheet is required, Lordship, and Lordship permit me time, Lordship, to file the Lordship.
No, I will permit you to, but the point is that what will happen
Lordship,
in 3 weeks' time.
Lordship, in fact, Lordship may submit, Lordship. If he was so apprehensive, first there is no apprehension of his arrest, he is also not making any submission that there is a NBW against him. I don't know, Lordship, the exact question, Lordship, whether NBW, because for that I have to, but even in his submission, Lordship, he is not submitting that there is a NBW, Lordship. So that
Is
apprehension
there
is
any NBW issued against you so far?
No,
There is
no,
no
no. Leadership, what has
apprehension, only
happened is
cognizance
I
taken
got
quite
a
possible,
summons
Lordship.
and a
Only
charge sheet
summons
has been filed
must have been
against me.
issued.
We'll ask them. Nothing is going to, heaven is not going to fall in 3 weeks' time. We are asking you to file a contract.
No, but till then, leadership, I be protected.
You are already protected. Nobody is going to.
No apprehension.
No, you have no apprehension of arrest as of now.
No, leadership, I will just let me explain it. My only apprehension was when I received summons. I had two options.
You
I would
have to respond to the summons.
no,
That you will
I'm-
not permit.
No, as far as leadership summon goes, we have immediately filed 438. So my 438, it has been rejected. Thereafter, I have come before the High Court. I am not going anywhere. I am a seasoned businessman in Delhi, working from last 40, 30 years. Got the entire work by a tender process.
That's
All the communications are there. My bank guarantees were there. So I am there. My only apprehension is that kindly protect me till then. Let them file a counter affidavit if we are not able to make our case good. This case is of 2010 leadership,
that's
and we are in 2026. I'm only saying that he's a family man, be protected till then. If we are not able to make out our case, a decision may not be held in my favor. No difficulty. Only this much I'm saying.
Third, the learned counsels appearing on behalf of the parties. Counsel for CBI. Praise for
3 weeks time.
3 weeks time. Praise for and is granted time till time till 11th August.
Must.
It is 2 days less than 3 weeks.
But
2 days less than 3 weeks.
I'll try my best. Please. I'll try my best.
Or maybe 12th of August. By to file counter affidavit by 12th of August 2026. Pose this case on 13th of August. At this, the learned counsel for the learned senior counsel for the petitioner appearing online has prayed for some interim protection. He submits that upon receipt of summons, they appeared before the court and filed their anticipatory bail application. And charge sheet has already been submitted and investigation is complete. In view of their aforesaid submissions, let there be there may not be any coercive steps against the petitioner.
Lordship, may
Till
only pray.
क्या होने वाला?
I'm not. Lordship may just record my objection. Lordship, that since there is no apprehension.
The learned counsel for the CBI has submitted that there is no apprehension of arrest and therefore he does not deserve any interim protection. No
Am I
coercive
like
steps.
decision?
Yes. It is only till 13th.
No difficulty. We will be here on 13th.
With the appearances.
Item 2, ABA 4158 of 2026.
I just don't know how you start with an argument. I've already heard this matter with other colleagues. Memory to every evening clean country.
In this case, the case was lodged in the year 2024. 25. 25. 25.
Counter नहीं आया ना इसमें.
First time.
Again,
First time आया बिना counter के.
अभी इसमें एक मेरा submission था कि we are ready to cooperate. We are the employee. The petitioner is the employee of the Nation Solution.
आप ही तो हैं राजा.
हम तो employee हैं. ये chief executive officer service है. Accountant भी नहीं है.
अच्छा कोई बात नहीं बिना counter के क्यों नहीं सुने आप?
तो हम बोले कि हम cooperate करने के लिए investigation को तैयार हैं. इसमें भी कोई क्यों उसका यही बात.
Anticipatory bail सिर्फ आप cooperate करने के लिए तैयार हैं इस ground पे नहीं
नहीं, हम मेरिट पे ही बात कर रहे हैं. हम बेल तो नहीं बात कर रहे. मेरिट पे ही बात कर रहे हैं. बोले कि कोई डेट है हमको भी बुला लें. हमको बुला लें हमारे इंक्वायरी जो भी करना चाहते हैं पूछ लें हमसे जो पूछना चाहते हैं. मेरे ऑलरेडी
counter affidavit. You see, anticipatory bail merely because a person is willing to cooperate.
They are not willing to cooperate. There is absolutely no allegation of this. So not say
No allegation. Washing file कर दीजिए.
allegation तो बाद में एक सर्टिफिकेट का नोटिस देके एक allegation बना.
आप ही सारा कंप्यूटर सिस्टम में सब डिलीट किया. यही है ना?
नहीं कंप्यूटर सिस्टम जिसके पास CEO चीफ एग्जीक्यूटिव ऑफ द सर्विस डिपार्टमेंट सैलरी है. CEO इज नॉट द ऑनर. एक कंपनी में डायरेक्टर को ऑलरेडी पकड़ के अंदर ने एंटिसिपेटरी पे ले चुका करेगा. ये मतलब बिजनेस है. entire case is that we are supporting business. एक अकाउंटेंट के बारे में बोला गया था कि ही द अकाउंटेंट उसके पास सारा कंप्यूटर का एक्सेस है और कंप्यूटर सीज
कंप्यूटर कौन डिलीट किया ये कहां से पता?
ये तो अकाउंटेंट के पास से सीज उस समय यही बहस था कि अकाउंटेंट उन्हीं के पास. मेरा तो वर्कशॉप में रहता है. अकाउंट मेरे यहाँ से कोई कंप्यूटर पे सीज नहीं तो वर्कशॉप में ये कंप्यूटर सारा सीज
डोंट हैंडल एनी
नो नॉट एट ऑल व्हिच वाज सीज.
सीईओ के अंडर में बहुत लोग काम
चीफ एग्जीक्यूटिव सर्विस डिपार्टमेंट मेरा शोरूम है गाड़ी का. उसमें सेल्स स्टोर अलग होता है, सर्विस अलग होता है, वर्कशॉप अलग होता है. वर्कशॉप इनके यहाँ पे इनके प्रेजेंस में 2 बार सर्च एंड सीजर हुआ है।
सुनिए ना इनकी कहानी अब आप काम करें।
अरे मेरा ही कहना है।
How much time?
अभी एक इसी के कोई उसके केस में पार्टी ऑर्डर बिफोर बेल एक उसको ऑर्डर पास किया गया, तो कॉपरेट विद दैट।
This case is different. In that case, we have 5 times given him notice under 35C. He has not appeared.
In this case, prior to notice, prior to my arrest, prior to arrest of the inquirer, he was called twice by the ACP. Without notice, he appeared. His house was searched. He put his signature in the seizure list. Entire thing was taken.
As a matter of principle, बिना respondent को opportunity दिए हम bail भी नहीं देते।
हाँ वो तो ठीक है, तो सुनना चाहिए, बट अब ये तो bail नहीं मांग।
तो आप क्यों जबरदस्ती क्या
जानना चाहते हैं कि जो पूछना है पूछ ले, जब वही तो है, तो इससे अच्छा
हम आपको नहीं भेजना चाह रहे हैं।
इससे अच्छा गेस्चर क्या होगा कि हम खुद जाना चाहते हैं कि
बहुत अच्छी बात है, your gesture is very good। जैसे ही नोटिस आए चले जाइए।
नोटिस इस केस में क्या हुआ है कि नोटिस मेरे एम्प्लॉयर को अरेस्ट करेंगे, दूसरे केस में बुलाए थे, तीसरे केस में अरेस्ट करेंगे।
टाइम टिल 5th of August, 5th August तक हो जाएगा। We need more time.
Yes, in fact.
Time till 5th of August is granted to the respondent to file a counter affidavit. Post this case on 12th, on 6th August.
Item 3, DA 67.4 of 2026.
This is a draft resolution, rejected by your lordship. Although it is remaining custody for 7 months.
Madam, custody will not be long.
7 months, your lordship observation was that after framing the charge, but still the sanction has not been received.
Sanction has not happened.
I have annexed the entire
When
order.
was the charge sheet submitted?
Charge sheet was submitted.
This year.
It was submitted on
16 to 26.
yes, 16 to 26. He is assisting your lordship on daily wages. Your lordship, in one of the case, although here it's a cap of 6,000. Your lordship.
Madam, it is not a matter of 6,000. It is a matter of 6,000 persons.
Person, yes, okay. But in one of the case where the petitioner was the contractual employment, your lordship, after the 4 months custody, your lordship is pleased to know.
I have granted bail to many people.
I'm not saying that, your lordship, it's not. He's in custody since
Madam,
18th of December 2020.
so what? Whatever be the custody. What is the status of the sanction?
Because may come up with an affidavit.
You file an affidavit. Because as per you have pointed out that section 90,
Yes,
altogether you have 4 months.
yes,
Right?
yes.
And the charge sheet has been submitted on 16 to
February, yes,
So 16 February plus 4 is
yes.
2.
Yes.
If you have exceeded, we have no option but to grant it.
Yes.
And I will record it.
Yes.
And whosoever is the sanctioning authority, whenever you have sent for sanction,
Yes.
you have to bring it up.
We shall state everything.
You should. And you inform the sanctioning authority also that bail will be granted by recording that because of his non-action, bail is being granted. And I will ensure that this order goes to his service record. Tell him very, very clearly.
We shall do that.
Yes. BA number 6744 of 26. The bail application has been filed second time. Earlier, the bail application was rejected with an observation that the petitioner may renew his prayer for bail after framing of charge. The learned counsel for the petition has submitted that on 16/2/2026, charge sheet has been submitted, but sanction for prosecution had not come till 22/6/2026, as is apparent from the order. The learned counsel for the state, for the ACP, is not in a position to explain as to why the sanction has not come. However, he pays for time. To file a counter affidavit. Let the counter affidavit be filed by 5th of August. Post on 6th.
Under heading for admission, item 4, AGA 3228 of 2026.
Offences under section 13 to 13(1)(b) of BC Act as well as 420, 467, 471, and 120 of IPC. For case of prosecution must and be able to annexure 1 must page 19. One nine. Very interesting.
We are aware of this. You tell us what is your case.
Yes, yes. Then must kindly have a look to those relevant partners at page 20. Page 20.
Yes.
सेकंड paragraph जांचकर्ता के द्वारा 23 दाखिल खारिज वादों का अवलोकन करने पर पाया गया इस सूची में 14 ऐसे प्लॉट का भी दाखिल खारिज किया गया है जो आयुक्त कार्यालय हजारीबाग का प्रक्रिया सचल के अनुसार गैर मंजूर खास किस्म जंगल खाते की भूमि है subsequent that notes at the bottom end of the page notes so as matter of allegation against petitioner is concerned ये कहते हैं आरोपण में खाता संख्या 73 प्लॉट 812 कुल रकबा 0.76 एकड़ किस्म कांड रैयती खाते की भूमि है जिसका खतियानी रैयत प्रसाद भूमि दर्ज है इस भूमि के दाखिल खारिज में कोई आपत्ति नहीं है क्योंकि ये रहती subsequent to that note so as matter of objection of prosecution is concerned खाता संख्या 95 प्लॉट संख्या 848 गैर मंजूर खाते की भूमि है जिसका किस्म जंगल है इस भूखंड के दाखिल खारिज पर आपत्ति है क्योंकि यह गैर मंजूर खास किस्म जंगल भूमि है तथा इसका गैर वाणिज्यिक कार्य है तो सदन से कैसा है Nominal so far as matter of allegation against this petition is concerned he has taken power of attorney from settled Rayat in the year 2006
नाम बताइए किससे power
that is continues from yours is 28. It is their document.
28. You just tell me, no? किसका power of attorney?
It's not sure. He has taken from the several persons, Bhagwan Prasad Gupta, Ishwar Dayal Gupta.
Page number?
Page number 27. One deed is part of FIR.
So he has taken power of attorney from several persons.
From several persons, in the year 2010 itself, registered power of attorney after proper verification of the land trust, whether the person who is giving power of attorney to him were in peaceful possession or not.
No.
Subsequent,
You must have verified the title also.
Yes, miss. That is there, miss. I can
Title and possession, he verified everything.
Yes, miss. Subsequent that notes in the year 2010.
Power of attorney is not transfer, you are an agent.
This was Minister was power of attorney was he was acting as an agent of parties. Seller was selling, purchaser was purchasing. I have just acted as an agent of sellers, which is evident from their document itself. In 2006, registered power of attorney was executed in favor of consumers. He sold the piece of land, so far in matter of 28 decibel is concerned, to one Vinay Kumar Singh and Sridhar Singh. Sale deed was executed in the year 2010.
Yes.
Subsequent to that, in 2013, Jamabandi was cancelled. In the year 2013. And present FIR has been instituted in the year 2020.
Jamabandi was earlier running in whose name?
In the name of persons who have given power of attorney to this person.
No, persons means who this 28 decimal
Yes, yes, yes.
of land was standing in whose name?
Because in the name of Bhagwan Prasad Gupta, Ishwar Dayal Gupta, Sakaran Gupta,
All these persons.
Yes, yes.
So the power of attorney was only for this 28
28
decimal?
Yes.
The power of attorney was only for 28 decimal?
Yes, ma'am.
Show me from the power.
Yes, ma'am. Page 28 में सी एडिट में
बताइए ना कहाँ?
28 नाम से जमीन बिक्री करने का 3 किता आम मुक्तानामा निबंधन कार्यालय हरियाणा उसका है आम मुक्तानामा निबंधन कार्यालय हरियाणा में दिनांक 7/2/26 को निबंधित कर दिया गया। इसका पहला किस्त आम मुक्तानामा बुक नंबर 4 वॉल्यूम 2 पेज नंबर 489 458 रीड नंबर 88 सन 2006।
अच्छा ठीक है, let us take it for a moment.
Yes.
That the power of attorney was only for 28 decimal and you sold this.
Yes.
And then the Jamabandi was cancelled.
Yes,
What was the ground for cancellation of Jamabandi?
Yes, sir. That is evident from their FIR itself.
You tell me what is the ground for
Page
cancellation?
19. What is it, nurse? A प्रारंभिक जांच was conducted nurse 18/10 एवं 24/15 में पूर्व जांच करता के बाद 23 दाखिल खारिज वादों का अवलोकन किया गया था, जिसकी सूची अक्सर ए संलग्न है। जांच के दौरान पाया गया कि उपायुक्त कार्यालय हजारीबाग जिला राजस्व शाखा का पत्र संख्या 67 दिनांक 67 द्वारा 5 प्लॉट का बिहार झारखंड भूमि सुधार अधिनियम 1950 की धारा 4/155 संख्या 67 की कंडिका 5 एवं 6 में वर्णित प्रावधान के अंतर्गत अवैध जमाबंदी रद्द किया गया था, जो निम्न है। Page 19 number से table and level. In that table numbers, so far as matter of land or public water is concerned, that has not been answered. Meaning thereby, so far as matter of jamabandi of the piece of land, whose power of attorney was being held by the petitioners, has not been considered.
So why are you an accused in this case?
It's their partners to explain. Let me conclude.
They have explained it in contract. You have not read the contract?
Yes, sir. I have gone through that. So, salary was excluded in the 2010, for which FIR has been excluded.
Do you want to say that whatever the land which whatever you sold,
Yes,
that Jamabandi was not cancelled? It
so
was
far as matter of
cancelled.
this plot number is concerned.
This plot number 95?
Yes, yes, yes. Plot number khata number 95 was plot number 848. That has not been mentioned in table.
Khata number 95?
Plot number 848.
Plot number 848,
Yes.
which was sold to Binay Kumar Singh
And
and
Smita
Smita Singh. So that Jamabandi was not cancelled.
Not yet.
This is area 28.
28.
If that be so, you have a full proof case.
This is
Yes, respondent. Is it correct? Whatever you say.
The entire records are missing. This particular Jamabandi 481.
Yes.
The entire records are missing, which we have stated in para 15. This particular Jamabandi entire records are missing. Para 15.
And in whose name is this property?
Yes, that we have stated in para 14. He has claimed to have got the power of attorney of Bhagwan Prasad Gupta, Prem Prasad Gupta and others, whereas we have clearly stated that and it was recorded in register 2 belonging to Pradeep Kumar Jain and Rajesh Kumar Jain. And her ladyship, we have further given para 9, 10 and 11. He doesn't only have this particular power of attorney. It appears that he is one of the main mastermind. He is having power of attorney of several huge chunks of land which we have given in para 9, 10 and 11, which have come in our investigation. One is from this Bhagwan Prasad Gupta, Ishwar Chandra Gupta, 884 so and so, 89 decimal, then 50 decimal, then 101 decimal. The next
Yes.
and
This property was not even recorded in whose name you are holding the power of attorney.
and only one thing, her ladyship, that the landowner who had allegedly given the power of attorney alleged landowner who has given her bail, his bail has been rejected by this court and actual seeker.
That I'm clear.
So as a matter of land concerned, that was auction and sold by municipal magistrate in execution.
We are not here deciding your titles.
No, I'm not on title nurse. I am on that nurse.
You see that you're the person who has given you the power of attorney,
Yes, nurse.
right?
Yes, nurse.
His bail, his anticipatory bail has been rejected. So you cannot say that he had some other title.
No,
You are not here to explain his title.
no, let me.
You are the person. I'll tell you one thing.
Yes.
The statements of other co-accused has also been recorded under section 1.
Yes.
There was a clear conspiracy to sell this land.
Nurse, mere presumption, nothing on record to nurse connect this petition for a document.
That we will see at the stage of bail, not at the stage of anticipatory.
Please kindly consider some few things. Nurse.
I've considered, I've heard you.
Nurse, please, nurse, kindly consider few things. I have not yet concluded. Nurse. Kindly
Concluded means what?
My
I'm
argument.
hearing you for the last 15 minutes.
3-4 minutes, nurse.
You can go and argue for 15 days.
No, nurse. Kindly consider few things. It deserves to be considered. Nurse, by
How
this
many
nurse.
few things? How many few means what? How many?
2-3 minutes.
I'm not talking about time.
Yes, nurse.
Which other points? How many more points do you want?
I'll be able to explain nurse.
How
again.
many? Give me the number. 2 points, 3 points. How many more points you want? Argue point wise, no?
Point. Yes,
So I'll deal with point wise.
yes.
So tell me, how many more points do you want?
Nurse, my first submission is nurse, it is our power of attorney holder.
Okay. First is you are just power of attorney.
Power of attorney holder, I was acting in same point nurse, I was acting as an agent between seller and person. First. Second
You are
nurse,
just a moment.
yes.
The person who has given you the power of attorney is also stationed in Jharkhand or he is stationed somewhere else?
Case in Jharkhand.
Number 2.
Number 2 nurse, power of attorney was executed in the year 2006, against which sale was executed in the year 2010, and FIR has been issued in the year 2025 nurse after 15 years of delay, without having any appropriate explanation for such a big delay.
So you want the entire proceeding to be quashed? You go and file
No,
quash.
I am on jail only. I am just seeking nurse. I am on anticipating nurse to be protected by your nurse. So my second point is that.
Second point is delay.
Third nurse, so far as matter of petitioner is concerned, petitioner is private person. So far as matter of Prevention of Corruption Act is concerned, nurse.
PC Act is not.
I will not be applicable against this petition.
And fourth point?
And categorically, nurse, so far as matter of 467, 468, 471 is concerned, petitioner was not in official capacity nurse to manipulate the revenue records which is being kept by the concerned authorities.
Right.
So nurse, it was beyond his capacity to manipulate it. To a specific allegation of that is specifically for doing mutation of the land here in question. So mutation record or जो concerned relevant चीजें हैं, it is has no concern with all those records. Neither concerned us not nor he documents are accessible to the petitioner being power of attorney for them.
You must be instrumental in filing an application for
So
it.
because only presumption is there at the hand of prosecutors.
I'm just asking your conduct.
That is because there on the document being power of attorney holder I
आप
accepted.
सारा document तो missing है. फिर क्या करें?
So it's custodian of the documents are concerned authorities belongs. Deputy commissioner, circle officer, circle inspector, those are the persons.
The mutation had taken place. On yes or no?
Yes, sir, so just mutation taken place.
Had
But
taken.
not
At whose instance?
your power of attorney holder.
He must have participated in the mutation proceedings.
No, it's being power of attorney holder. Mutation was to be done by concerned circle officer after proper verification of the document. You are just acting as an agent bureau.
Very good.
Not when a single dispute land has been mutated in favor of this petitioner.
Very good.
Not when a single transaction from the account of this petitioner to the account of this petitioner.
Okay.
So in order to connect the petitioner with alleged offense, there must be some relevant concrete document evidence at the hand of prosecution.
There is no angle of criminal conspiracy.
No, lastly,
Yes,
reported.
fifth point.
We have received notice under section 35 criminals, and I am ready to cooperate in the investigation wherever they require. I will be available physically to cooperate in the investigation. Or I will be avoid the law terms and conditions whatever will be imposed by the investigation officer.
That's all.
Yes, sir.
The learned counsel appearing on behalf of the petitioner has submitted that. Let me hear the response. Yes, respondent, what all you have to say? All these you have already said, delay and everything, whatever is there in the contract. Or the learned counsel appearing on behalf of the parties. Para 1. The learned counsel for the petitioner has made the following submissions. 1. The petitioner happens to be the power of attorney of number of persons with respect to the property involved in this case, which is just 28 decimal of land in Khata number 95, plot number A48. And being the power of attorney, he had sold the property to Vinay Kumar Singh and Sita Singh. The power of attorney, apart from that, he has no role to play. He has acted merely as an agent. 2. The power of attorney is of the year 2006. The land was sold by registered deed in 2010, and the case has been instituted in 2026, and there is delay.
25 years. Yes, year of case is 25 years.
25.
Yes.
Case has been instituted in 2025, and there is delay of 15 years in lodging the case. Number 3, the petitioner is not a public servant, and therefore Prevention of Corruption Act is not active. Number 4, there is an allegation that the land records, the mutation records relating to this property and other properties are missing, but the petitioner has no access to the office, and therefore he cannot be held responsible for that. Number 5, the petitioner is ready to cooperate with the investigation. That's it. The learned counsel for the ACB has opposed the prayer for bail, for anticipatory bail, and has submitted that, and has referred to and has submitted that the FIR was registered with respect to land scam that has surfaced in the district of Hazaribagh, wherein Gair, Majurba, Khas land, forest land, government land, Gujar land, or lands which are either Gair Majurba or Khas are being illegally transferred by sale, purchase, by land mafias, government officials, seller purchasers, by committing criminal conspiracy amongst themselves, and by manipulating government records. And has submitted that the petitioner is not only the power of attorney of the property involved in this case, but he is the power of attorney of huge chunk of land, and he is the main person who is instrumental in transferring the aforesaid land. He has referred to paragraph 9, 10, and 11 of the contract affidavit. He has further stated that he has further referred to paragraph 14 of the contract affidavit to submit that the property which was sold was not even standing in the name of the person who had executed the power of attorney in his name. As per Register 2, the land was recorded in the name of Pradeep Kumar Jain and Rajesh Kumar Jain, both sons of Kushan Lal. He has also referred to the statement of the co-accused recorded under section 183
Yes, ma'am.
183 BNSS, as wherein it has come as to how the entire conspiracy was hatched and the land was transferred. The learned counsel submits that the person who had executed the power of attorney in favor of the petitioner, namely Prem Prasad Gupta, his prayer for anticipatory bail has been rejected by AP number 2636 of 2023 by order dated 11/6/2026. The copy of the order is placed. He has also submitted that should be sufficient. After hearing the learned counsel for the parties and considering the fact that the petitioner being the power of attorney sold the land to the two co-accused, namely Vijay Kumar Singh and Snigdha Singh, as a part of conspiracy in transferring land in Khata number 95, plot number 848, which were in the nature of Gair Mazulma Khas jungle land and notified as protected forest land, for which a reference has been made to paragraph number 394 of the case diary. The fact remains that the entire mutation records are missing, and as per the counter affidavit, there is a likelihood that the petitioner would influence the witnesses in this and tamper the evidences. The fact also remains that Prem Prasad Gupta has been denied the privilege of anticipatory bail. This court is of the view that enough material is available against the petitioner, and it is a case of land scam in which numerous persons have conspired, and therefore and the petitioner being the power of attorney holder and the person instrumental in getting the land transfer has certainly a role to play. So far as the argument of the petitioner that the PC Act is not applicable, the argument is completely misplaced. It's a case where criminal conspiracy is involved with other government officials. the argument of the petitioner that it was beyond his capacity to maintain the record, to influence the record, is also completely misplaced. In the aforesaid facts and circumstances, this court is not inclined to grant the privilege of anticipatory bail to the petitioner.
Item 5, ABA 3355 of 2026.
Not this matter as a matter of last opportunity and praying for 3 or 4 days time only for the
4 weeks was granted to file affidavit.
that's what I'm
They are
saying.
not filing.
That's what I'm
The
saying.
only allegation of 7 in your, no proof of acceptance is there. And
Because the instructions are coming today itself, only 4 or 5 days. As a last opportunity. If my lord so please.
in this case, I am the junior engineer in the minor engineering division. I need some interim protection so that if they are willing to counter claim, they may file it. In 4 weeks, they do not file it.
आप अपना जॉब कर रहे हैं,
मतलब जॉब नहीं कर पा रहे हैं अननेसेसरी
आपको सस्पेंड कर दिया गया,
सस्पेंड नहीं किया गया है
तब क्या कर रहे हैं?
मतलब आई एम वेटिंग एज सम काइंड ऑफ interim protection so that I can
छुट्टी
continue
पर है? Are you on leave?
yes Lord I am on
फिर आप जाइए घूमने फिर क्या?
Lord, only allegation of 7 is there, my Lord. No proof of acceptance there. Only allegation is there.
CDR
And
है.
yesterday I received the
CDR
RTI.
है, CDR है.
Lord,
आप भाग गए ऑफिस से तो क्या?
Lord, हम अपने हम ऑफिस से भागे
Just
नहीं,
tell.
हम फील्ड में.
You just tell me. Demand, acceptance and recovery से ट्रैप कम, ठीक है? लेकिन अगर सिर्फ डिमांड है, ठीक है, और उसके बाद एक्सेप्टेंस ना हो पाए या whatever, पीसीआर बनता है कि नहीं बनता?
Lord, as per Supreme Court in Legal Tata judgment, they are said to establish any offence under Section 7 of Prevention of Corruption. Demand and acceptance must be there. But acceptance must be there. It is a sign on to establish an offence under Section 7 of Prevention of Corruption.
Just
In this case,
demand
only
will not.
allegations. Only allegation of demand of 50,000 is there. There is some
We
negotiation.
will examine it, right? We will examine it. Right? Trap has remained incomplete, correct? Yes, right? You, even if you establish demand, acceptance तो हुआ नहीं, आप at best demand ही establish कर पाइएगा. You have to satisfy this court till the case is made out. Correct?
Right.
बस. अभी क्या स्टेट है? क्या चल रहा है अभी? ठीक है, you file your contract.
Interim protection may be
इसीलिए
given.
लोगों को दिक्कत होती है contract में file करने.
That is
AD
why-
number 3355 of 2026. In spite of order dated 25/6/2026, counter affidavit has not been filed. आपको क्या इंस्ट्रक्शन है? How much time do you need? The learned counsel for the ACB prays for and is granted time till next Wednesday to file the counter affidavit. Just a moment. At this, the learned counsel for the petitioner submits that some interim protection will be granted. Since counter affidavit has not been filed in spite of order dated 26/6/2026, 25/6/2026, and there is only allegation of demand so far as against the petitioner, and there is neither any recovery, there is no recovery from the petitioner till 30th July there shall be no course of examination. Post on.
Item 6, DA.23.07.2026.
So, इसमें जो last shape of liaison that he demands 7,000 rupees as a guide.
आप क्या है?
रोजगार सेवक और कॉन्ट्रैक्ट बेसिस
पंचायत सेवक,
yes madam
रोजगार सेवक.
हाँ रोजगार सेवक 6/2/2026 से कस्टडी में हूँ और चार्जशीट सबमिट हुआ है 2/4/26 को और अभी तक सैंक्शन
As per the PC Act, sanction for prosecution कितने दिन में?
3 महीना का ये दे चुके हैं अभी तक आया नहीं 3
3
महीना
plus
27/4/26
1.
27/6/26
तो ये तो 2/4 को ही हुआ है.
ये
4 महीना कब एक्सपायर कर?
ये 4 महीना हुजूर करेगा 2/4/26 को हुआ है चार्जशीट तो 2/8 को करेगा
2/8 को करेगा ना. तो इसलिए अभी आप मत बोलिए कि अभी तक प्रोसिक्यूशन सैंक्शन नहीं आया है. That cannot be a ground for your bail. BA number 3606 of 2026. The learned counsel for the petitioner submits that the petitioner is in custody since 6/2/2026 and is Rojgar Sevak of Saraidi Panchayat and he has been alleged to have got red-handed with bribe money of rupees 7,000 for making entry of his field for irrigation well construction. The learned counsel submits that charge sheet has been submitted on 2/4/26, but prosecution sanction has not. During the course of the learned counsel for the state has submitted that, as per the PC Act, there is a timeline for grant of prosecution sanction, which is 3 months, and additional 1 month is also available, and the time has not yet expired. The learned counsel for the ACB has opposed the prayer for bail and has submitted that after completing all the procedure, the trap was laid and the petitioner was apprehended with bribe money. After hearing the learned counsel for the parties and considering the fact that the petitioner was apprehended with bribe money, red-handed, this court is not inclined to enlarge the petitioner on bail. However, the petitioner may renew his prayer for bail after framing of charge. आपके पास चार्जशीट में कितने गवाह होते हैं in practice generally?
Usually members and informant members, shadow witnesses members, 1 or 2 members, the police witnesses members. Altogether members maximum 5-6 witnesses.
और थोड़ा pre-trap memorandum और ये सब के बाद 8 to 9. Trial कितने दिन में conclude होता है?
सैंक्शन ही नहीं मिलता है 1 साल तक में
अब यहाँ पे सैंक्शन का कहानी नहीं होने वाला. सैंक्शन आ ही जाएगा, आप देखिए. You take up the matter for sanction. The learned counsel for the state is also directed to inform the sanctioning authority that the matter regarding grant of sanction cannot remain pending for unlimited period.
पैराग्राफ 12 में ये
And he has
काउंटर में पैराग्राफ 12 में काउंटर में लिखे हैं 27/4/2026 को सैंक्शन के लिए भेजा गया है बट अभी तक 2.5 महीने बीत गया है सैंक्शन में
4 महीने का टाइम.
हाँ ठीक है तो हम उसको नहीं डिनाई कर रहे कि 4 महीने का टाइम है इसको हम डिनाई नहीं कर रहे पर 2.5 महीने में अभी तक सैंक्शन नहीं गया
कोई बात, अभी तक टाइम नहीं बीता, प्रीमेच्योर Right.
और सेक्शन नहीं आया तो कॉग्निजेंस नहीं होगा तो चार्ज नहीं
Item 7
देखिए
PA
चार्ज
5
फ्रेम नहीं
06
होगा
of
ठीक है ना,
2026
लेकिन अगर फिर भी सैंक्शन नहीं आता, अभी आज भी एक केस है कि भाई टाइम एक्सपायर कर गया, सैंक्शन नहीं आ रहा है, तो हम जेल में थोड़ी रहेंगे क्योंकि चार्ज फ्रेम नहीं होगा। आप आइएगा तब हम इनसे पूछेंगे, अभी से हम कैसे इनसे पूछेंगे? तो कोई दिक्कत नहीं, ऐसा तो नहीं कर सकते वो लोग कि आपको जेल में रखेंगे और सैंक्शन नहीं देंगे।
appearance review. Item 8 BA 5007 of 2026.
There is a dispute between my government about the case has been registered as section 1091 of BNS. In which the best 16 is there, I will there was a quarrel between my husband and in which the petitioner assaulted his wife, causing injuries on her.
Previous पूरा मुंह तोड़ दिया उसका, जिसको मुंह तोड़ना बोलते हैं ना, वही के क्रश कर दिए उसको मुंह।
No, ऐसा नहीं है।
ऐसा ही।
And you see the medical. It is only saying grievous cannot be a grievous. And it is diary has called for, injury report was also called for. I am custody more than 6 months, and when there is a chance of also reunion and para 6.
कौन है यहाँ पे इन्फॉर्मेंट?
नहीं।
यूनियन का चांस है आपकी
लोकल लेवल में वो रह रही है, मेरे ही घर में रह रही है तो
आपके घर में रह रही है तो आपको छोड़ना और डिफिकल्ट है।
कोई डिफिकल्ट
नहीं छोड़ेंगे।
पेज 16 और केस डायरी में
जब तक उसका गवाही नहीं करवा दीजिएगा तब तक नहीं छोड़ेंगे।
इसको मंडे को रख दिया जाए, गवाही बात नहीं पूछ लेते हैं, ये भी हो गया है, 7 महीना हो गया है कस्टडी गवाही का, 1 सप्ताह बाद ले लेंगे। इंजुरी जो आया है, डॉक्टर इज सेइंग seems to be grievous, but expert opinion is required. He is not saying that it is grievous. But the size of injury is required. It is only 2 cm into 1 cm. It is not that it is a हुआ क्या धक्का देने में मुंह में चोट लग गया। ऐसा है तो नेक्स्ट वीक कोई एवरीथिंग इन मतलब 4 दिन ब्रांड और दवा एंड 7 महीना हो चुका है, चार्जशीट मार्च में ही हो गया, फरवरी में मार्च चार्जशीट।
चार्जशीट कब हुआ?
10 को।
Office is directed to call for the present status of the case and specifically indicate as to whether the victim has been examined before the court. Post this case on 5th of August.
Item 9 BA 5010 of 2026.
My petitioner is the husband or initially a FIR was registered under section 1031 238 35 of the BNS. Later on, manner charge sheet have been submitted under section 82 of the BNS manner. If manner may see using the case diary, address this is the case of 108 manner. Minor may kindly have independent
charge sheet
82 में 80 सब 304 मैडम ने काइंडली have
आप हमको एक बात बताइए, 82 में तो चार्ज शीट हुआ, चार्ज फ्रेम किसमें हुआ?
चार्ज फ्रेम नहीं
चार्ज। तो अभी हम यहाँ पे ये सुने कि आपका चार्ज शीट जो है 108 में होना चाहिए।
नहीं,
तो क्या सुने हम
इंडिपेंडेंट विटनेस का दिखा रहे हैं,
ये उससे आप कुछ करना चाहते हैं कि 108 में होना चाहिए।
There is no opinion in the postmortem report की डेथ कैसे हुआ है।
इसका क्या मतलब?
इंडिपेंडेंट विटनेस बोल रहे हैं कि बच्ची का बर्थडे था, बेटी का बर्थडे था, केक लाने के लिए वाइफ बोली थी, शाम में केक लेके नहीं आया तो लड़ाई झगड़ा हुआ, उसके बाद बच्ची के साथ माँ भी जाके वहाँ एफएसएल रिपोर्ट भी नहीं है, कहीं एफएसएल रिपोर्ट भी नहीं आया, कोई ओपिनियन नहीं है, कोई एक्सटर्नल इंजरी नहीं है।
और बाकी जो एफआईआर में वो सब झूठ, और
बाकी
जो विटनेस बोल रहे हैं सब झूठ।
यही है कि
for the learned counsel appearing on behalf of the parties, the counsel for the petitioner submits that petition is in custody since 3/1/26, 3/1/26, 28/1/2026, and charge sheet has been submitted under section 18(2) of BNS, but the case diary would reveal that the charge sheet ought to have been submitted under section 108.
80 surplus 2.
किसमें होना चाहिए 108
10.
under section 108 of BNS. It's a case of suicide, and the dispute arose as the husband did not bring cake on the birthday of his child, upon which the wife and the wife committed suicide along with the child by jumping into the well, and there is no antemortem in the matter. The learned counsel for the state has opposed a prayer for bail and has submitted that there is direct allegation of demand of dowry to the extent of rupees 4 lakhs and a 4-wheeler. For that, the deceased was being tortured.
And 1 4-wheeler.
Sorry?
And 1 4-wheeler.
And 1
4-wheeler.
and 1 rupees 4 lakhs and 1 4-wheeler vehicle. The marriage was solemnized in the year 2023. After hearing the learned counsel for the parties and considering the allegation regarding demand of dowry and the marriage and the lady died along with the child in her matrimonial home within 3 years of marriage, this court is not inclined to, the petitioner being the husband, this court is not inclined to revise the petition. Rejected. Always at this stage, I'm not fight कर सकते हैं.
Item 10, DA 5014 of 2026.
In this case, charge sheet has already been submitted and charge has been framed also, under section 137(2)(96). The petitioner is not named in the FIR. The FIR is against Shivam Kumar, and during the course of investigation, the victim has only stated in the diary that the person what is stated. Is the Jija of Shivam Kumar.
Read the FIR.
Yes, my lord.
She
FIR.
was taken to Chennai.
Chennai, yes.
What's the
By
age?
Shivam Kumar.
By Shivam Kumar.
Yes.
How is Shivam Kumar related to victim?
Shivam Kumar दोनों कहते लव अफेयर चलेगा.
अच्छा 12 साल की लड़की.
Yes, that is against Shivam Kumar.
Just a moment.
Yes.
Who are you?
Jija of Shivam Kumar. मेरे खिलाफ इतने ही आया है during investigation that Shivam Kumar हम लोगों को भगाने में this petitioner has assisted. This is the only.
काफी है ना?
यही है. This is only that. May I read that relevant portion also?
काफी है.
Milord, they have fled away. They have Milord without.
नहीं तो 12 साल की
हाँ तो
लड़की है.
Milord everything by Shivam Kumar Milord, and for that Milord the Jija Milord only 1-2 paragraph.
शिवम कुमार कितने साल का है?
शिवम कुमार उसे एज ग्रुप है.
Same age group
20 साल का लगभग.
20 साल का.
हाँ
और
18
आप
साल
कितने
का.
साल के हैं?
Oh, he is 14 years. She is 14 years as per the.
आप कितने साल के हैं? कि आपको बुद्धि नहीं है?
Milord हमको my age is Milord ये मेरे खिलाफ है ना मोटरसाइकिल पर भी जो देखे हैं शिवम कुमार Milord FIR में ही कहते हैं कि
charge sheet has been submitted under section.
charge sheet Milord under section 137(2)(96), 65(1), 351(2), 61(2), 35 of BNS.
लिख के दीजिए.
Charge is for these cases. सिर्फ मेरे ऊपर एलिगेशन ये है कि जीजा जो है मदद किया भगवाने में, मगर FIR में कहती है इंफॉर्मेट कि शिवम कुमार मोटरसाइकिल से लेके भाग गया, शिवम कुमार लेके भाग गया, ना हम उसके साथ देखा गया हमको। अब विक्टिम यही है कि आई हैव असिस्टेड, हो सकता है मनी दिए होंगे, पैसा दिए है, व्हाट टाइप ऑफ असिस्टेंस आई हैव गिवन दैट इज नॉट डिस्क्लोज्ड, दैट इज माय मतलब अपार्ट फ्रॉम दैट सिंस आई हैव द जीजा देयरफॉर आई हैव ये भी 21-22 साल का।
Victim का statement 183 का था।
183 has been called for.
Yes.
Yes.
She became pregnant also. She became pregnant also.
Yes, yes, that is there. जो भी है सो admitted है। मेरे पर जो एलिगेशन है
Heard the learned counsels appearing on behalf of the parties. The learned counsel for the petitioner submits that the petitioner happens to be the brother-in-law of the main accused, namely Shivam Kumar. The victim aged 12 years. Eloped with Shivam Kumar and went to Chennai. And the only allegation against the petitioner is that the petitioner helped the co-accused in the entire act. The learned counsel submits that the petitioner has been falsely implicated in this case and he is in custody since
22-2026 charge sheet has been submitted, charge also framed like these sections.
शिवम कुमार की शिवम नहीं तो है
शिवम कुमार कहीं लिखे हैं, कहीं शिवम ना हो।
इनके केस में क्या है अपार्ट फ्रॉम दिस क्योंकि विक्टिम इनका कोई नाम नहीं 183 में she has not taken this statement
नहीं इसमें 180 में लिए 180 सीआरपीसी में पुलिस के पास बोले हैं कि शिवम कुमार महतो का जीजा हम लोग को मदद किया था भागने में ये 180 पैरा मिनट दैट इज पैरा कंडिका 133 मिनट।
The learned counsel for the state has opposed the prayer for bail and has submitted that the victim had also become that it has come that victim also became pregnant on account of the incident. After hearing the learned counsel for the parties and considering the nature of allegation against the petitioner, this court is not inclined to enlarge the petitioner on the incident.
Item 11, DA 5015 of 2026.
Initially, the case under section 109 was registered. Now, the reason was, if you also can look at the first FIR, and it's still one.
Just a minute.
But I may told the earlier it was withdrawn.
Withdrawn by which court?
By your lordship's court, madam.
Okay. Yes, which page? Where is the order of withdrawal? It was simpliciter withdrawal or after some argument?
Simple.
Okay. Which page are you referring?
That is at page 32.
32, Your Lordship.
And it should be.
Page 32 is the order.
Yes, that's right. So,
Yes.
What's the allegation? 2-3 things I want to know. What is the present stage of the case?
Charge frame,
Okay.
no witnesses in exam. Two witnesses. Just one.
Okay. 2 witnesses have been examined.
Examined.
Out of how many?
Out of I'll just say, out of 10. Out of 10, my lord.
Okay. Now, what is the allegation?
Allegation. If you are scanning, look at the FIR. Now, there is a case and a counter case.
Page number?
Page number 28.
Yes, 28.
I may read it out, madam.
Yes.
निवेदन पूर्वक करना है कि मैं राजेश यादव पिता सचिन सच उम्र सचिन सच घर थाना पेटरवार तेनुगा टोपी जिला बोकारो के रहने वाला दिनांक 19/7/25 को मैं अपने बच्चे को लेने के हेतु गरवाटान शिव मंदिर के पास इंतजार कर रहा था। गणेशान यादव को पंडरा पिता जगन्नाथ गोप साकी नीचे टोला मुझे देखकर गाली गलौज देने लगा। जब मैं गाली गलौज देने से मना किया तो वह नहीं माना। तभी स्कूल का गाड़ी आ गया और मैं बच्चा लेने जैसे ही आगे बढ़ा तो मेरे गर्दन पकड़कर मारपीट करने लगा। तो मैं उसे धक्का देकर बच्चे को लेकर अपना घर साइकिल से चला आया। कुछ देर आधा घंटा बाद आकर मेरे घर में ईंटा पत्थर चलाने लगा और गेट खोलकर निकले तो देखे कि घनश्याम यादव का बेटा रंजीत यादव धीरे से पिटिशनर लॉर्डशिप दिवाकर यादव दोनों के पिता घनश्याम यादव की पत्नी सभी मिलकर मेरे घर के अंदर घुसकर मारपीट किया। तो अपने हाथ में लोहे का रड से रंजीत यादव जान मारने के लिए से मेरी पत्नी के माथे पर मारा और सर फट गया, जिससे काफी खून निकलने लगा। घनश्याम यादव का पत्नी मेरे पत्नी कुमारी का मंगलसूत्र नीचे लिया और उसे बीच में मेरी पत्नी का झोटा पकड़कर दिवाकर यादव पिता घनश्याम यादव घसीटने लगा। जब मैं दौड़ाने लगे तो मुझे लात से मारा और ईटा पत्थर से हमला किया। काफी हल्ला होने लगा, गांव के लोग जमा हो गए। हम लोग वहां जाना बचा भी धमकी दिया कि सभी को जान से मारकर फेंक देंगे। पत्नी का साड़ी खींचकर लज्जा this is the FIR. Now there is a counter case and that is 109.
Where is that?
That is murder. Annex 3.
Page number?
33.
33?
33.
Arising out of the same incident? arising out of the same incident?
Yes.
Same.
Where Mandu Yadav received injuries.
So far as this lady is concerned, she received grievous injury or
She received and she died.
she died also?
Mantu Yadav died.
No, lady has not died.
Lady not.
Lady
The
has not
lady
died.
received what nature of injuries?
Brother of the informant has died.
Simple.
Lady simple. Mantu Yadav.
Mandu Yadav died. Initially,
Subsequently he died during treatment.
And his name is not in the FIR. Mantu Yadav was assaulted by
In the I'll take it just. दीजिए का कॉन्ट्रैक्ट इनका जो FIR है in this FIR nobody died.
No, our side was nobody else.
In the FIR involved in this case.
where I am accused.
Yes, where you are accused.
Where I am accused, they say as per the FIR कि wife को मारा नहीं
Wife को मारा.
but subsequently wife को injury simple है, but this Mantu Yadav जो है उसपे as per FIR there is no allegation that he has been assaulted, but he died.
He died. Died out of injury.
Died of injury.
Died out of headache.
And his statement, because the idea is not before your lordship, mother. In his statement, it says this petitioner has assaulted Mantu Yadav.
That's right. And then your counter case.
Counter case is there.
What is the allegation in counter case?
And counter case, I just been there. I read it out. Page 36. Page 36, my lord. Has it not seen?
Yes, I'm there.
समझा निवेदन ये है कि घनश्याम यादव में मैं अपना खेत से घर जा रहा था, उसी क्रम में करवाटा शिव मंदिर के पास मैं बैठा तो पिता दुखलाल यादव पुत्र राजेश यादव ने मुझे चिढ़ाने लगा और मुझे गाली गलौज करने लगा और मुझे मारने लगा। मेरे आंख में चोट लग जाने की वजह से कुछ दिखने नहीं लगा, जिससे मैं कुछ नहीं कर सकता, जिससे मेरी भाई
This is not arising out of the same incident.
Same thing.
No, it is not the same incident.
Well, same place the incident, it is our discussion of the incident. Well, you will also can put the timing. Place of occurrence.
Time is there. Place of occurrence is not the same.
Yes, yes. Date of occurrence.
Date of occurrence is the same. But place of occurrence is not the same. Same time में दो जगह. Place of occurrence, time of occurrence.
No,
Place
it
and time.
It is not their case that they can deny in the annexure 3.
That's right. So you want to yes. So if you say that it is a counter case arising out of the same incident, so the incident is admitted, isn't it?
Yes, there is a case and counter case.
Incident is admitted.
But so far allegation of assault on Mandu Yadav is concerned, that is as per the FIR, it's not on me.
It is not
This-
there in the FIR.
They say Ranjit
Yes,
Yadav
yes,
must be
yes.
wife को मारा.
In the wife did not suffer much
नहीं,
injury.
wife suffered simple injury.
That's
हम
But-
पे Ranjit Yadav की पत्नी पे मारा.
but who assaulted the deceased? Who assaulted the
This
deceased?
petition had
From where do I get this?
paragraph 65 जो केस डायरी
Confession से चलेगा.
कन्फेशन दिया है
Confession से चलेगा.
नहीं कन्फेशन दी और इसी के कन्फेशन पर रिकवर हुआ रॉड जिससे इन्होंने असॉल्ट किया है।
आप हमको ये बताइए, रॉड से असॉल्ट किया, इनको मारा, ठीक है? तो FIR में तो कहीं है ही नहीं कि इनको मारा. तो कहाँ से ये आ गया स्टोरी?
नहीं पैराग्राफ 7 में है।
हाँ, पैरा 7
7 होता है
7:15:18 is the relevant paragraph of the witnesses, and para 23 notice para 50 is the user Mantu Yadav.
पैरा
Head
50.
injury, para 50 of the case died.
नहीं, वो तो head injury है. There is no doubt that he died out of some injury caused due to rod. But the point is that where do I get who hit him? Because in the FIR there is no such allegation.
Plus is para 7 of the case died.
Yes.
7, 15 and 18 is
You just show me one thing that it was a petitioner who had hit him, or during the incident he was hit.
इसमें है दिवाकर वगैरह सब मिलकर मेरे भाई मंटू यादव को पकड़ा और रंजीत यादव ने पीछे से मंटू यादव का गर्दन के ऊपर सिर के पीछे मारा. That is paragraph 7.
And who is the petitioner here?
Ranjit Yadav.
Ranjit Yadav.
The place of occurrence as per the FIR is the same place.
Para 7 कहाँ है? पढ़िए तो.
मिडिल पोर्शन में घनश्याम यादव की पत्नी सभी मिलकर हरवे हथियार से लैस होकर मेरे घर के अंदर घुसकर मारपीट की है, जिसमें दिवाकर वगैरह गर्दन के ऊपर सिर के पीछे से निकलकर लोहे का रड से मारा, जिससे मेरा भाई मंटू यादव वहीं पर गिर गया. मेरी पत्नी रिंकू कुमारी को मारा, जिससे मेरी पत्नी का भी कपार फट गया. अब भतीजी सुमन कुमारी को दिवाकर यादव पकड़ गया.
Divaker has already been announced. Divaker has already been announced.
Where is the
रंजीत
author of
यादव
Divaker?
दिवाकर यादव.
Where is the author of Divaker? Order of bail to Divaker.
Ma'am, look statement नहीं.
You saying that Divaker has been enlarged on bail.
Paragraph 60 भी नहीं.
आपके मेंशन करने से क्या होगा मैडम? Where is the order?
Divaker है.
केस नंबर बताइए.
Case number है BA 10,172 of 2000.
ना तो आपने पिटीशन में लगाया, ना कोर्ट के पास है. Now you are saying court has been enlarged on bail. Para number?
Para number 16.
60. इसका ऑर्डर निकालिए. BA number 10172 of 25.
पारा 15 में भी आया हुआ है.
इतना क्यों?
10 charges.
10. Out of 10, 2 have been executed.
And place of occurrence as per the FIR in the case and counter case is the same place. I've seen it from that.
See, the moment there is a counter case arising out of the same incident, the incident stands completely admitted by both the parties. It's a high risk area. You know it better than me.
But your Lordship, as per them, case study, your Lordship.
Para 15 is also there, para 7 is also.
Para 7 में हम.
पारा 15 में आया है.
So that is a contradiction. Para 7 में देखा
अब
जाएगा.
contradiction था
हाँ,
यहाँ पे नहीं
एक बार
देखना।
हम पर. Your Lordship, we need to case study. Because I don't.
इसमें तो बिना केस डायरी के ऑर्डर नंबर 2 might not have been brought to the notice of the court that somebody has died also. हाँ. नहीं पता चल रहा. Only the allegation in the FIR, because FIR में तो किसी के मरने की कहानी है.
No, but it's a fact, your Lordship, which we have.
That's right.
We are not denying. The your Lordship, एक बार para 7 पढ़ देते हैं, then para.
Please, we have read it.
Para 7 में your Lordship, the relevant line is आधा घंटा बाद मेरे घर से ईटा पत्थर चलने लगा, तब गेट खोल कर देखे तो एकजुट होकर घनश्याम यादव को 15 पिता सुमन रंजीत यादव एंड दिवाकर यादव, पिता घनश्याम यादव एंड घनश्याम यादव की पत्नी सब हरवे हथियार से रेस होकर हमारे घर में घुसे, जिससे दिवाकर मेरे भाई मंटू यादव को पकड़ा और रंजीत यादव ने पीछे से मंटू यादव के गर्दन के ऊपर अनेक बार लोहे कर नाउ दे से यहाँ पे your Lordship, जबकि FIR में he doesn't say about this occurrence. Subsequently,
Yes.
so that is three only there. All the three were there. This Ram and the Divaker.
Or the learned counsel is appearing on behalf of the parties. The learned counsel for the petitioner submits that the petition is not named in the FIR.
His name is there.
Just a moment. Although the petitioner is named in the FIR, but there is no allegation in the FIR that the petitioner ever assaulted Mantu Yadav,
Who has died?
who has died on account subsequently on account of head injury caused by drug. The learned counsel submits that the entire dispute arose on account of some dispute relating to a child, and there is case and counter case between the parties. With respect to the stage of case, it has been submitted that out of 10 witnesses, 2 witnesses have already been examined, and charge has been framed under
Charge has been framed subsequently to witness.
charge has been framed under which sections?
103.
103.
Charge has been framed under section.
That is in the
It is
FIR.
there in the
And I mentioned in paragraph 14.
right. Impugn order may be declared in para 14. The learned counsel submits that the petitioner is in custody since
3rd of August 2026. I mentioned
3/12/2025,
3.
which is almost a year back.
Management.
The learned counsel
No
for the,
criminal.
the petition has no criminal. The learned counsel for the state and the informant have opposed the prayer for bail and has submitted that it has come during investigation in paragraph 7 of the case diary that it was the petitioner who had assaulted Mantu Yadav by rod, and ultimately Mantu Yadav died due to such an injury. He has also submitted that the FIR may not disclose every fact, but this was disclosed immediately after the FIR was immediately after the FIR the report was given to the police. Correct?
During treatment, he died.
Even the lady victim who suffered minor injuries has also made similar allegation against the petitioner. After hearing the learned counsel, to this the counsel for the petitioner has submitted that the accused, namely Ghanshyam Yadav and Divakar Yadav, have been granted bail in PA number 10172 of 2025 by order dated 25/11/2025. After hearing the learned counsel for the parties and considering the aforesaid statement recorded in the case diary, which is directly against the petitioner and which caused death of Mantu Yadav, this court is not inclined to enlarge the petitioner on bail. So far as the bail granted to the co-accused is concerned, the bail order itself revealed that a submission was made by the petitioners that there is specific allegation of assault against petitioner against Divakar Yadav and co-accused Ranjit Yadav. And Ranjit Yadav is the petitioner before this court. Therefore, the case of the petitioner is not similarly situated as that of the person who has been granted bail in DA number 10172 of 20. In view of the specific materials which has come during investigation, this court is not inclined to enlarge the petition on bail. A counter affidavit filed during the proceedings is taken on bail.
Item 12, DA 5070/2026.
The offense under section 80 and 85 of the BNSS.
Yes.
The FIR has been registered against 5 active persons, including these two petitioners. The allegation note that the deceased was married with the son of the
Within 2 months.
Within 2 months of the marriage, she committed suicide as per the allegation.
Who are you?
The parents in paragraph 8.
What about the husband?
Husband blood is in custody. Now, case diary has been called for. If Rosi may kindly see the paragraph 3 of the case diary contains the restatement, which is not against all the persons but general allegations that they used.
Where did she die?
They used to do, like in the house of the petitioner. They used to demand.
We cannot ignore the role of the parents.
4, 5, 6 are the hearsay witnesses. Paragraph 4, 5, 6. So far, no independent witnesses are concerned.
बेल के अलावा आपको क्या चाहिए मुझे बताओ?
बेल में होगी बेल का केस एक आदमी को जिसने ननद था उसको तुम मिला
उसको तो देना
यूपीएन एक्सेप्टिंग
सासू माँ को
सास ससुर है जरूर लेकिन इन पर एलिगेशन अगर एक भी लाइन दिखा दे
क्या एक लाइन तो आप ही को एक्सप्लेन करना है 304
postmortem report does not show any sort of injury below on her person.
There is an allegation. अब अलग अलग का थोड़ी बोलेगी वो फलना तारीख को बताया
लोकल
काफी सर काफी
43, 44, 45
2 महीना में सर
लोकल जो बोल रहे हैं
एक लड़की के बारे में सोचिए 2 महीना में she is off.
But this is committed suicide.
Suicide
Yes, sir. The fact remains on 9th of April 2026. Charge has been framed, and they are in custody since not more than a year. 15th July 2025. Charge has been framed. I have stated in
charge framed on.
There are 9th of April 2026.
9/4/26.
Not a single witness could be examined by the.
वो examine आप कर पाओगे. BA number 5070 of 2026. Heard the learned counsel submitting on behalf of the parties. The learned counsel for the petitioner submits that the petitioners happen to be the parents-in-law of the deceased who died in matrimonial home, but she had committed suicide. The learned counsel for the state and the informant have proposed the prayer for bail and has submitted that within 2 months of marriage, the deceased died in unnatural condition and there was a demand of motorcycle. Considering the nature of allegation, this court is not inclined to enlarge the petitioners on bail. However, it appears that the charge has been framed. To this, the counsel for the petitioner submits that charge has been framed on 9/4/2026, and there are altogether 10 charge sheeted witnesses, but not even a single witness has been examined so far. The state is directed to ensure that the witnesses are promptly produced before the court. The next date is 25th of August 2026. The state is directed to ensure that the witnesses are promptly produced before the court. The counsel for the state is directed to communicate this order to the SP of the concerned district and also to the Director Prosecution to ensure compliance. Any FSL? No FSL?
Item 13, BA 5081 of 2026.
Yes.
The case of cybercrime, earlier withdrawn by lordships because we are having no notice.
Withdrawn by lordship. Did I withdraw?
No, before your lordship.
Okay.
And there was recovery of one mobile with 3 SIMs.
Just a minute. One mobile
With 3 SIMs.
3 SIM.
2 SIM belongs to the petitioner, matter 27.
That's right. Further.
For the matter of this, one victim of rupees 10,000, matter 37.
Okay.
And there are 11 crime links. Para
11 crime links.
Yes. I'm in custody since 29/9/2024. Charge has been framed, but no witness has been examined.
And one antecedent.
Yes, one antecedent. It's a link.
Charge has been framed on 7/5.
Yes.
What do you say?
This is actually so many percentage of part 34 of the year also. The case that has come that from the same mobile loss,
Para 34.
34 years.
That's crime.
That is crime leak in many states, from many states.
Any FIR institute? Any FIR institute?
But they have cheating because it's come in the crime.
अब तो सीजर ही नहीं प्रूव कर पाते हैं, आपका क्या ही कर सकते हैं. Or the learned counsel submitting on behalf of the parties. The learned counsel for the petitioner submits that the petitioner is in custody since 29/9/2025, having one criminal antecedent of similar nature.
Yes, similar.
तीसरा बार मत आ जाइएगा मेरे पास. Having one criminal antecedent, he submits that it is alleged that one mobile, 3 SIMs have been recovered from the possession of the petitioner, and one victim has been identified. Though as per the case diary, there are 11 crime links. Relating the charge has been framed on 7/5/2026, but no witness has been examined so far. The learned counsel for the state has opposed the prayer for the. After hearing the learned counsel for the parties and considering the custody of the petitioner and no witnesses being examined by the state, the petitioner is directed to pay only.
Item 14 BA 5090/2026.
Under section 64 and 69 of the BMS laws. This case talks it there is a delay of 1 year 7 months in lodging the FIR.
Read the FIR.
Now that
FIR
laws. That is page 18.
Yes.
निवेदन को करना है कि मैंने इसमें परिण करी 23 वर्ष पिता सचिन सच गिरडी का निवासी है साहिल पिता साहिल चक्कू सचिन सचिन सच गिरडी का निवासी है साहिल का पिताजी का दुकान बनगंजे में है कभी कभी इसका दुकान सामान लेने जाती तो समय साहिल भी दुकान में रहता था सामान लेकर लौटने के क्रम में अक्सर साहिल मेरा पीछा करता था मुझे इस रास्ते में रोका करता था इसी क्रम में वर्ष 2024 मई महीने में एक दिन दोपहर में साहिल दुकान पे सामान लेने गई थी दुकान में साहिल अकेला था पिता कोई नहीं था साहिल इसका फायदा उठाकर मेरा मुंह बंद करके जबरन पकड़ के दुकान के अंदर ले गया जबरन पकड़ के तंग रोने लगी अपने पिता से बताई साहिल मुझसे बोला मैं तुमसे प्यार करता हूँ शादी करूंगी इस चीज से मुझसे आश्वासन भी दिया इसका साल बार बार मुझसे दबाव बनाता रहा जिससे मैं मना करती रही जब साहिल ज्यादा दिन करने पर मैं मिलने नहीं जाती थी तो धमकी देते हो जाता था मेरे पास तुम्हारा कुछ नंगा वीडियो फोटो है जिसे सोशल मीडिया में वायरल कर दूंगा डर से उसके बाद मानते हुए कई बार मिली जब साहिल मुझसे मिलता था तो मेरे साथ जब साहिल फिल्म बनाता था शादी का झांसा देकर साहिल पिछले 1 वर्ष से लगातार
victim का age
23 years that's it condition and accept 20 and accept
आप भाग गए थे
नहीं लॉर्डशिप दिसंबर में एफआईआर हुआ मार्च में फाइल एंटीसिपेटिव माय एंटीसिपेटिव वे नॉट रिजेक्टेड दैट सिंस 82 has been issued that I have withdraw this case I just surrender
भाग नहीं बोलते इसको
हम नौकरी कर सब लगाए हम बाहर औरंगाबाद में जॉब कर रहे थे
oh you are working in Aurangabad
अब जस्ट हम
ये जो साई की दुकान में जाती थी
ये सब हम दिखा रहे हैं, सब हम
नहीं।
एविडेंस पूरा दिखा रहे हैं। हम आज तक हम वहाँ गए नहीं, पूरा एविडेंस में बोले इंडिपेंडेंट विटनेस।
कहाँ से आ गए
अचानक मेरा कॉल डिटेल आया लावे गया और हम लगाए हैं कि मेरा जो चैट होता था जो हम ट्राई टू अंडरस्टैंड कि हम शादी भी हो गया, मेरा एंगेजमेंट हो गया, तो बोली कि हम बात नहीं करेंगे तुमसे। जस्ट पेज 20 देखा गया एनेक्स 3 नोट्स हम पढ़ा दे रहे हैं थोड़ा सा। तुमको तेरी अम्मी की कसम सच सच बोलना। हाँ बोलिए, मेरी मंगनी हो गई है था, हम तुमको बोले थे कि हम बात नहीं करेंगे, ना ही शादी करेंगे, बोले थे ना? हाँ बोले थे। ये भी बोले थे कि शादी हम अपने घर वाले की पसंद से करेंगे। हाँ हमको पता है। और ये बोले थे कि आपको जहाँ करना है, आपको जहाँ करना हो हम करेंगे। हाँ ठीक है, अब मेरी शादी का डेट फिक्स हो गया है और शादी होने के बाद केस की है मेरी हुई। मेरा शादी हो गया देयर आफ्टर द एफआईआर है। और हम लगाए भी हैं, जो हम पूरा मई में जून में पूरा अटेंडेंस सीट लगाए हैं जहाँ हम जॉब करते हैं।
And inter-religion
No, no.
नहीं। Informant कौन है? Informant कौन है?
रेशमा
ठीक है, यही Third, the learned counsel is appearing on behalf of the parties. The learned counsel for the petition submits that the petition is in custody since
13/4/2026.
13/4/2026. It submits that the petitioner and the victim were in talking terms, and the FIR has been lodged in the year in December 2025. 25, na? December 2025. And as per the FIR, the incident had taken place in May 2024, wherein the petitioner is alleged to have raped the victim, and it is alleged that in the pretext of marriage thereafter, the petitioner has been exploiting the victim and has raped her repeatedly. The counsel for the petitioner has submitted that the petitioner is already married and he has been falsely implicated in this case. आपको क्या बोलना है? आप इंफॉर्मेट हैं? हाँ बताइए।
बोल रहे हैं कि शादी हो गया, अभी तक इनका शादी नहीं हुआ, सिर्फ मंगनी हुआ है, बात इन लोग का हुआ है, अभी तक शादी नहीं हुआ। इनायत जो बोल रहे हैं शादी, ये व्हाट्सएप चैट में बोल रहे हैं कि हम बोल दिए हैं कि हम शादी नहीं करेंगे तुमसे, फिर भी लेकिन व्हाट्सएप चैट में आया हुआ है, ये एडमिट किए हैं कि तुमसे शादी करेंगे, तुमसे ही शादी करेंगे।
Just a moment.
Page 60-61 is relevant.
The learned counsel for the informant has opposed the prayer for bail and has submitted that the petitioner has not yet married. Rather, the petitioner has been repeatedly telling the victim that he would marry the victim. To this, after hearing the learned counsel for the parties and considering the direct and specific allegation made against the petitioner that he has committed rape upon the victim, this court is not inclined to enlarge the petitioner on bail. And after going through the statement of the victim recorded under section 183 AS, this court is not inclined to enlarge the petitioner. नहीं, आप हो गया.
Item 15 BA 5149 of 2026 along with item 16.
Yes. Pass over नहीं होगा. Adjourn कर दीजिए. Next. Petitioner prays for adjournment. The petitioner prays for Passover. Big day.
Item 17 BA 5174 of 2026.
Is the case of 103 of the BS. Last occasion, the FSL report of the blood sample has been pulled for me.
FSL report is come.
But not. Yes, ma'am. वो आ गया अभी just inform receive किया.
The learned counsel for the state submits that he has received the necessary instructions in terms of order dated 9/7/26. Pose this case tomorrow?
Yes.
After 1 week. चलिए डेट बताइए कौन सा चाहिए? Next week का कोई
next week
जगह देख के दीजिए. 29 and 30th को बहुत केसेस
जी. Item 18 BA 5182 of 2026.
Earlier withdrawn was 9/4/26. This case of rape is found in that year.
It was withdrawn after Samadhi. It was withdrawn after Samadhi.
Yes.
All right. Yes.
Now the phrase found in that year, the charge has already been framed on 29/5/26.
29
5/26.
5/26.
We have not annexed on just copy of charge, user copy, certified copy of charge, but not a single witness has been turned up for 8 minutes. I'm in custody since 29/8/25.
And one antecedent.
One antecedent. I have one antecedent.
And how many persons have you treated?
Well, as many as 7 persons were apprehended by the police officers, and out of 7 there were 6 have been convicted because I have
I'm not asking, that is not my question. My question is that how many persons, how many victims have been identified?
One victim is the evidence. 58.
One victim and
One victim.
how much amount? How much amount?
98,000.
98,980.
About 99,000.
Okay. And how many crime names?
Crime 9 crime names. One mobile set, one SIM card.
क्या बोलना आपको? और the learned counsel से pleading होंगी आपको. The learned counsel for the petition submits that earlier the bail application the petition was withdrawn by BA number 10977 of 2025 or by order dated 9/4/2026. The submits that now the charge has been framed on 29/5/26. But till date, not even one witness has been examined. The submits that the petitioner has one criminal antecedent. However, the petitioner in the present case is in custody since 29/8/2025. To further submit that one mobile one SIM was alleged to have been recovered from the possession of the petitioner, and One victim has been identified. The learned counsel for the state as opposed to the record. However, the unfortunate submissions are not in dispute. He additionally submits that there are 9 crimes. After hearing the learned counsel for the parties and considering the custody of the petitioner, and in spite of reading of charge, witnesses are not being examined by the prosecution. आप sure है ना?
Sure. Verify कर लिए.
The petitioner is directed to the international.
Item 19, DA 5185 of 2026.
देखिए, petitioner case को pass over post on नहीं हो सकता, pass over के लिए time नहीं बचा.
Item 20, DA 5192 of 2026.
इनका केस नेक्स्ट थर्सडे को ये एसीबी का है. हाँ भाई, जिनका नंबर है वो अपना केस नहीं कर रहे हैं. ठीक है, कोई बात नहीं, फ्यू केसेस के लिए नहीं हो सकता है क्योंकि आज मेरा बोर्ड ही कंप्लीट नहीं होगा, पास ओवर का नंबर नहीं है. ठीक है, मंडे को नहीं, एसीबी का केस थर्सडे को. यस, बताइए ये कौन है, हु इज पिटिशनर?
Item 20.
Yes. Where is the order of withdrawal?
I have given the statement paragraph 2.
ऐसे आप नहीं लगाइएगा ऑर्डर तो कैसे? इतना मेरा काम नहीं है. काउंसिल पर पिटीशन से नेक्स्ट वीक ऑर्डर नहीं लगाते हैं, देखे भी नहीं.
Item 21, BA 5315 of 2026.
I am appearing on behalf of the department.
पिटीशनर को अरेस्ट करना. आपको वकालतनामा नहीं फाइल,
वकालतनामा फाइल की
काउंटर फाइल करना है. कितना टाइम चाहिए?
2 weeks.
2 साल क्यों नहीं?
2 weeks.
2 साल क्यों नहीं चाहिए?
अच्छा 1 week.
Counsel for the informant is present. He prays that the matter be posted next week, post on next Thursday.
Copy of the petition will be given.
आप उनसे मांगिए ना. The counsel for the petitioner is directed to provide a copy of the entire records of this case to the counsel for the informant during the course of the case.
Item 22, BA 5360 of 2026.
Petitioner absent. Next week. Next week. No problem.
Item 23, PA 5370 of 2026.
अभी डेट मत दीजिएगा, ठीक है? वो डेट हम लोग वेट समझ के देंगे. Yes. नहीं, खोलिए उसको, खोलिए दीजिए. Age 13 years.
Age 13 years, madam.
FIR पढ़ी. ट्रायल तो चल रहा है, कितना विटनेस हो गया? इंप्यून ऑर्डर छोड़िए, आपको नहीं पता है कितना विटनेस हो गया?
हमारे से इंफॉर्मेशन से एक्यूट
ना, आप ऐसे कहाँ से इंफॉर्मेशन करेक्ट? योर इंफॉर्मेशन इज नॉट करेक्ट, ऐसा लग रहा है. अब तो आपको ट्रायल कंक्लूड करने में कोई दिक्कत नहीं है ना. अब हम ये सब देखिए, आपका जो ये जितना भी ये सैंपल है, यहाँ पे हमको इसको देख कर कोई ऑर्डर नहीं करना, इसको एक्सपीडाइट करना है, इसीलिए करना है. ठीक है. PA number 5370 of 2026. For the letter counsel's opinion on behalf of the parties, the counsel for the petition submits that the petition is in custody since 2/6/2025, having no criminal antecedent. The learned counsel submits that the petitioner has been wrongly made an accused in the present case. The learned counsel for the informant has stated state has opposed a prayer for bail and has produced a copy of the DNA report which he covered during the court proceedings. He submits that the trial is already going on and the trial is already going on. To this, the counsel for the petitioner has submitted that as per till 17/3/2026, only 1 out of 9 charge sheet cases were examined and he is not aware regarding the present status of the case. The learned counsel for the state has submitted that there is direct allegation against the petitioner. The petitioner will not be enlarged on bail. After hearing the learned counsel for the parties and considering the allegation against the petitioner and also the statement of the victim recorded age 13 years recorded under section 183 BNSS, this court is not inclined to enlarge the petitioner on bail. However, the state counsel is directed, इसका तो copy आया है ना यहाँ पर. The state is directed to ensure that the FSL report is forwarded to the concerned court. ये already forward हो चुका है. अच्छा, ठीक है, ये तो हो गया कहानी. The remaining witnesses are promptly produced with the वो usual जो रहता है ना. No one appears to रहेगा ही ना. Call करें.
Item 24, BA 5393 of 2026.
Initially, FIR is suited under section 302, 201 IPC, which has been charged under section 306.
Just a moment. 302?
201 of IPC.
Okay.
But charged after investigation, charged is submitted under section 306 or 34 of IPC. And the date of occurrence is 24/7/2023, but the FIR was on 28/7/2026, and petitioner
28/7/26. क्या बोल रहे हैं?
24/7/2023.
हाँ.
And FIR was on 28/7/2023. And petitioner is father-in-law. And the reading of FIR, there is
date of marriage.
Date of marriage has not been mentioned also.
आपको नहीं पता?
हम father-in-law हैं, बस यही लिखते हैं कि 2 साल पहले कहीं disclose नहीं informant is there.
आपको नहीं पता आपके बेटा का शादी कब हुआ था?
कहीं आया नहीं है चार्जशीट में भी.
Just a moment, counsel for the petitioner is directed to seek instruction.
लॉर्डशिप
बहुत खराब हो जाएगा.
तुरंत
बहुत सीरियस हो जाएगा. आपको समझ आ रही बात? informant है इसमें. बताइए क्या कहानी. FIR पढ़िए तो तब तक ये अपना डेट ऑफ मैरिज बता.
मैं बंदिया देवी उम्र 67 पांडेपुरा थाना पलामू के अस्थायी निवासी हूँ. दिन 24/7/23 दिन सोमवार को रात्रि में जगदीप यादव उम्र करीब 45 वर्ष, पिता वासु यादव, देवनारायण यादव, छत्तीसगढ़, देवनारायण यादव, वासु यादव, सपोज का नाम न मालूम, सभी ग्राम दुबई थाना पोस्ट नाम पर रहने वाले ये सभी लोग मेरी बेटी पुष्पा देवी उम्र 44 वर्ष, पति जगदीप यादव, ग्राम बधाई थाना मनातू, जिला पलामू, सभी लोग डाई बिसाई कहकर लाठी डंडा से मारकर हत्या कर शव को फांसी पर लटका दिए. हमको फोन द्वारा गांव घर के आदमी द्वारा सूचना मिला कि आपकी बेटी की मृत्यु हो गई. इसके बाद दिनांक 25/7/23 को सुबह 9 बजे हम अपने बेटी के घर आए. लॉर्डशिप को देखे कि मृत शरीर चारपाई पर लेटा हुआ था.
लॉर्डशिप पारा में आई सी द पारा 44 and 45
ये सभी लोग बिना सलाह लिए हुए मेरी बेटी का अंतिम संस्कार भी कर दिए।
पारा 44 and 45 में क्या है?
हुआ क्या था ये पोस्टमार्टम में आ जाता, लेकिन ये लोग जो है से जबरदस्ती दाह संस्कार किया है, एफआईआर करने से रोक रहा था, तब
दाह
हम 28
संस्कार
साल
आपने
को
किए?
नहीं, पारा 45, 44 and 45 independent witnesses have stated that the
ये
informant is
witness
also present at the time of the last criminal.
जब ऐसा था तो हम एफआईआर क्यों करते लोग? सिर्फ 28 साल
आया independent witness has specifically stated.
ये सारे लोग हमको जबरदस्ती रोक के रखे, दाह संस्कार कर दिए।
कहीं नहीं है कि जबरदस्ती होगी, ये स्पेसिफिक है, इम्पून ऑर्डर नहीं पाता है।
उनको भी एक्यूज बना दीजिए।
किसको?
इन्फॉर्मेंट को।
इन्फॉर्मेंट आया जो हमको थोड़ा सा
जब हम थाना जा रहे थे तो गांव घर के सभी आदमी तथा मेरी बेटी का सारा परिवार लोग थाना आने से रोक दिए। मेरी बेटी की 10 दिन पूर्व देवनारायण यादव और पुतोह प्रतिभा देवी दोनों डाइन भूत कहकर मारपीट किए थे, जिससे मेरी बेटी का सिर फूट गया।
और ना हम प्रतिमा देवी है ना देवनारायण यादव, हम फादर इन लॉ हैं, हम पर कोई एलिगेशन नहीं है एफआईआर में भी, और पारा 44 हम पढ़ देते हैं।
2023 के बाद से आप कहाँ?
हम एंटीसिपेटरी फाइल किए थे, which has been rejected. लॉर्ड्स एक चीज
सुप्रीम कोर्ट नहीं गए?
लॉर्डशिप
सुप्रीम कोर्ट भी गए थे?
नहीं उसमें एक चीज है, केवल हमको
2023 का घटना हो गया, 2026 में आप चल रहे हैं अभी, कस्टडी कब से है? 10/4/26
कस्टडी है 10/4/2026,
इसीलिए तो
80 साल का बुजुर्ग, 80 years old है पिटिशनर।
थोड़ा 2-4 साल बिता देते तो we do not know what could have happened.
लेकिन इसमें आया इंडिपेंडेंट
डाइन बोलकर आप बहुत
नहीं हम नहीं किए हैं, अगर किए भी हैं, अगर जो एलिगेशन भी है तो मदर इन लॉ, ब्रदर इन लॉ, सिस्टर इन लॉ हम पर नहीं है। हम तो सिर्फ है कि हम उस फैमिली का मेंबर है, इन लॉज है, फादर इन लॉ है, हम पर कोई एक भी वर्ड का स्पेसिफिक एलिगेशन होगा तो हमारा रिजेक्ट कर दीजिए। फर्स्ट, दूसरा, इंडिपेंडेंट विटनेस पारा 44 and 45 में स्पेसिफिक बोला है कि झगड़ा हुआ था ब्रदर इन लॉ और मदर इन लॉ से, सिस्टर इन लॉ से, छोटा सा बात के लिए, वो कुछ खाना बनाने या के लिए, और उसके बाद से वो घर में बंद हो गई और घर में सुसाइड की, और उसके बाद इन्फॉर्म किया गया इन्फॉर्मेंट को, इन्फॉर्मेंट आया, मुखिया आए वहां के, और सभी लोग प्रतिनिधि पत्रकार आए, सबके सामने की बात आया है कि सबके सामने जाके लास्ट क्रिमिनेशन हैज बीन डन। यहाँ लिखा हुआ है, हम इसी को थोड़ा सा हमको पढ़ने, इंडिपेंडेंट विटनेस क्यों झूठ बोलेगा, हमको पढ़ लेने दिया जाए। शंभू यादव
सुसाइड कैसे हो गया? बाय द
सुसाइड यही झगड़ा किए ब्रदर इन लॉ और सिस्टर इन लॉ के, इन्हीं लोगों के झगड़ा के कारण सुसाइड, यही बात आया, यही बात हमको पढ़ लेने दीजिए। शंभू यादव बयान दिए कि अपने बयान में बताया कि मृतका पुष्पा देवी की 3 लड़का, बड़ा देवनारायण, मझिला हरिनारायण और छोटका शिवनारायण उर्फ गोरा जी को बाहर में रहकर कमाते हैं। आगे बताया कि घटना के करीब 7-8 दिन पहले सास एवं पतोह मनिता देवी के बीच कुछ बात को लेकर झगड़ा हुआ। पारा 44 और केस डेट
ये लोग
इसी समय पढ़ लेंगे।
पैरा 44 तो सशस्त्र बल के साथ प्रस्थान किया।
53 तभी हमारा में जो है पहले वाला शंभू यादव का हम स्टेटमेंट पढ़े। मृतिका मनिता देवी के बीच कुछ बात को लेकर झगड़ा हुआ था। उसी समय देवनारायण घर में नहीं थे। झगड़ा के बीच मृतिका खेत में मकई कोड़ने चली गई। कुछ समय बाद देवनारायण यादव घर आए तो प्रतिमा देवी अपने पति को झगड़ा के बारे में सारी बात बताई, जिसके बाद देवनारायण यादव गुस्सा में खेत पर गया और अपनी मां के गाली गलौज करने लगा और मारपीट कर दी। तब मृतिका पुष्पा देवी को गुस्सा में थाना में शिकायत करने चली गई तो पीछे से देवनारायण यादव भी थाना गया और मृतिका के ससुर एवं ग्रामीण लोग भी गए। फिर थाना में समझा बुझा दिया गया। फिर थाना से सभी लोग वापस घर आ गए। इस झगड़ा के बाद मृतिका मायके से मृतिका के पिताजी आकर साथ में करीब 6-7 दिन रहे। उसके बाद रविवार को चले गए। जब मृतका के पिता जा रहे थे तो मृतका के ससुर बोले कि इनको भी आप अपने साथ कुछ दिनों के लिए ले जाइए, तो मृतका के पिता बोले कि नहीं जाना चाहती। सोमवार को रात में सभी मिलजुल कर खाना बनाए, उसके बाद सभी लोग अपने अपने कमरे में सोने चले गए। मृतका जिस घर में खाना बनता है उसी कमरा में अकेली सोती थी। सुबह में सब लोग जग गए, किंतु मृतका का कमरा का किवाड़ अंदर से बंद मिला। खोलने के लिए काफी आवाज दिए गए, जब अंदर से कुछ आवाज नहीं आया तब किवाड़ के चौखड़ के बगल में तोड़कर किवाड़ की बेला खोला गया तो देखा गया कि मृतका फांसी पर मृत पड़ी है। आगे पूछने
ये
पर
कौन
बताया
है? ये जो इनको इतना पता है,
उसी गांव के।
अरे भाई इतना कहानी घर के अंदर कब कौन किसको क्या बोल रहा है, ये कहानी इनको कैसे पता है?
हुजूर उसी गांव के बगलगीर हैं तो कैसे नहीं पता होगा
सब चीज
हुजूर?
पता होगा।
गांव में तो पॉसिबल है हुजूर, शहर में नहीं पॉसिबल है कि कोई किसी से मतलब नहीं रखता, लेकिन गांव तो सब इंटरलिंक होते हैं एक दूसरे से। पारा 45 में भी यही बात आया है। और जब इन्वेस्टिगेशन करके चार्जशीट सबमिट कर रहा है 406 में, अगर आयोग पाता कि हाँ हमारा कोई है, कोई भी एक भी एलिगेशन आता कि हम कभी टॉर्चर भी किए हैं, इवन कोई भी स्टेटमेंट में आता कि हाँ हम टॉर्चर किए हैं, इंस्टिगेट किए हैं अबेटमेंट करने का। लॉर्डशिप
चार्जशीट कब हुआ?
चार्जशीट हुआ है 5वां महीना में, 31/5/26।
आपको सुनिए ना, आप बैठ जाइए।
हाँ।
BA number 5393 of 2026. Heard the learned counsels appearing on behalf of the parties. The allegation is that the daughter-in-law of the petitioner was branded as witch in Diane, and she was killed. And cremated. The petitioner, the incident is of 27/7/2023. And the FIR was 24/7/23, and the FIR was lodged on 28/7/2023 after the cremation. After cremation?
After.
The learned counsel for the petitioner has submitted that the petitioner has no role to play. At best, there could be some allegation against his wife and his daughter.
Elder son.
And
his elder son.
His wife and his elder son.
Devanarayan.
Namely Devanarayan. The learned counsel for the petitioner has also submitted that the petitioner was availing the remedy of anticipatory bail, and ultimately he surrendered.
Lord.
He surrendered on 10/4/2026. Charge sheet has been submitted on 31/5/2026 against the petitioner under section 306/34. बाकी लोगों का किसी का ट्रायल नहीं है।
अभी और सरेंडर नहीं।
There is एक भी आदमी सरेंडर
नहीं और जेल में होंगे हम नहीं पता। I have no instructions.
That's right. The learned counsel submits that apparently his daughter-in-law committed suicide. He has referred to the case diary and has submitted that even the independent witnesses has stated that she had committed suicide. As she was found dead and the room was closed from inside. The learned counsel for the state and the informant have opposed the prayer for
एक लाइन मेरे तरफ से और लिखवा दीजिए जो इंडिपेंडेंट विटनेस बोले हैं कि at the time of last cremation informant were also present.
He has also submitted that at the time of cremation, the independent witness has stated that the informant is also present. The learned counsel for the informant has vehemently opposed the prayer for bail and has submitted that there is serious allegation with respect to the manner in which the daughter-in-law of the petitioner has been gained. He submits that the petitioner was that as per the FIR itself, the petitioner was the informant was क्या बोले उनको दूर रखा गया था.
बिना सलाह लिए हुए मेरी बेटी का अंतिम दाह संस्कार
As per the informant itself, as per the FIR itself, without consulting him, the cremation of his daughter was conducted. After hearing the learned counsel for the parties and after considering the nature, the manner in which the offence is alleged to have been committed by branding the daughter-in-law of the petitioner as which this court is not inclined to enlarge the petitioner on bail.
एक लाइन और लिखवा दो petitioner is age about 80 years.
The counsel for the petitioner submitted that petitioner is aged about 80 years.
Item 25 DA5533 of 2026.
पोस्को का केस है जो विक्टिम है वो PW1 एग्जामिन हुई वो कुछ टाइम I have a next.
Yes, madam. Victim hostile. She is an informant also?
No. Victim is grandmother of the victim. Informant is grandmother of the victim.
She has turned hostile.
PW2 is examined also.
तो 6 में से 4 एग्जामिन हो ही चुका है.
हाँ लेकिन इंडिपेंडेंट जब विक्टिम एग्जामिन हुई है वो स्टाइल हुई है इसके बाद PW2 इंफॉर्मेंट भी एग्जामिन हुई है वो भी स्पेसिफिक कुछ नहीं बोल रही है उसमें तो विक्टिम है विक्टिम का ये
एक सेकंड यूपी वगैरह सब घूम फिर के आ गई. ठीक है क्या बोलिए यूपी नहीं गए थे.
यह केस मेरे नानी ने किया है.
कौन सा पेज नंबर
15 दिनांक 8/12/25 को मैं घर से भाग गई थी इसलिए नानी ने केस किया. मैं करण कुमार और छोटू कुमार के साथ उत्तर प्रदेश के बेलखारा गांव में चली गई.
बेल नहीं दे सकता.
कहीं एलिगेशन नहीं है ना सेक्सुअल असॉल्ट
का
नहीं कोई असॉल्ट का
लेके गया ना यूपी
नहीं वो अपने से भाग
गई लेकिन लेके गया भाग गई 14 साल की लड़की है एक ही बात.
ये तो लिख रही है कि अपने से हम भाग बोल रही है कि हम भाग गए.
बहुत अच्छी बात. BA number 5533 of 2026 or the learned counsel appearing on behalf of the parties.
ट्रायल एक्सप्लाइट करने का
The learned counsel for the petitioner submits that the victim has already been examined before the court and she has turned hostile. Out of 6 charge-sheeted witnesses, 4 have already been examined. 4 examined till
4% examined out of 6 PW.
Till when? Till 21/4/2026. He is not aware about the about the fact as to whether
अभी तक इंस्ट्रक्शन है कि
no further witness has been examined. The victim was admittedly less than 14 years on the date of occurrence. The learned counsel, आप स्टेट को क्या मन नहीं कर रहा है क्या काम करने का? कंसेंट से बिल देते हैं आपको?
No, there are points against.
Hold on. The learned counsel for the state has opposed a prayer for bail and has submitted that the evidence of the victim reveals that she had gone to Uttar Pradesh along with the petition. After hearing the learned counsel for the parties and considering the nature of allegation, this court is not inclined to enlarge the petition on bail. However, so far as the state is directed to ensure that the remaining witnesses are promptly produced before the court. But we will allow this.
Item 26, BA 5644.26.
In this case, the FIR had been instituted under section 121 and the clause 5 of BNS. In the FIR, there is a allegation that the deceased was going to his home, to her home, along with two children. And in the midway, two unknown persons stopped her and assaulted her with by means of the iron rod, and she died. And लास्ट में बोलते हैं मुझे शक है कि इंफॉर्मेंट के जो है इंफॉर्मेंट है वो डिसीज के भाई हैं, बोलते हैं लास्ट में मुझे शक है कि मेरे जीजा ने मरवा दिया क्योंकि प्रीवियस में इन लोगों में आपस में लड़ाई झगड़ा था. In this case, I have been implicated on the basis of my self confession and there is no TIP and I am in custody since 4/2/2026.
Self confession, आप तो वो है ना उनके
हस्बैंड,
तो आपका क्या टीआईपी होगा? हस्बैंड का भी टीआईपी होगा क्या?
नहीं, जो दो आदमी अननोन जो थे,
आप अननोन में से नहीं है ना?
नहीं अननोन से.
You are the husband. तो नो टीआईपी का क्या मतलब?
दोनों जो अनआइडेंटिफाइड थे उनका टीआईपी नहीं.
तो उससे कोई मतलब नहीं, वो भी पकड़ा गए.
हाँ, वो भी शायद पकड़े गए, एक तो पकड़े गए हैं, एक के बाद.
They were hired criminals.
हाँ,
उनके कन्फेशन में आपका नाम आया है?
नहीं, मेरा सेल्फ का कन्फेशन.
आपका सेल्फ, उनके कन्फेशन में आपका नाम आया है? आप जो सवाल पूछेंगे आपको पता ही नहीं.
बाद में मेरे
तो क्लीन चिट
बाद में
कोई बात नहीं. आया है, क्या बात कर रहे हैं?
रिकवरी भी है, अरेस्टिंग भी है, देयर आफ्टर अरेस्टिंग वेपन रिकवर भी हुआ है, ऑल थिंग्स.
GA number 5644 of 2026. The counsel for the petition submits that he happens to be the husband of the deceased, but he has been falsely implicated in this case. The petitioner was going with the deceased by scooter, and two unknown persons have assaulted the deceased and she died. But the informant alleged that there was continuous quarrel between the petitioner and the deceased, and it was the petitioner who had killed the deceased. The learned counsel for the informant and the state. The learned counsel for the petitioner has stated that, except the confession statement of the petitioner, there is no material to connect the petitioner with the alleged offence. The learned counsel for the respondent and the informant and the state have opposed the prayer for bail and have submitted that the petitioner had hired the criminal to commit the offense and he was instrumental in the offense, and on the basis of his confession statement there is recovery of the weapon used for committing the offense. That's all. After hearing the learned counsel for the parties and considering the associate facts and circumstances, and there is recovery on the basis of confession statement of the petitioner, this court is not inclined to announce the petition on bail motion.
Item 27, BA 5740/2026.
Petitioner please pass over. So next week.
Item 28, BA 5800/2026.
इसमें डायरी भी मांगा गया था, काउंटर फाइल की डायरी है।
काउंटर फाइल कर दी है
जी,
डायरी है,
डायरी आ गई है।
हाँ बताइए। 183 का स्टेटमेंट पढ़िए, सीधा सीधी एक ही, उसके अलावा क्या ही पढ़ना।
हाँ बस वही
पढ़िए।
183
क्या नाम है?
case of
petitioner से शादी कर ली, informant मतलब victim शादी हो गया।
yes, ma'am, as it appears from our statement files. They left together matters and thereafter then went to Nagpur, there they stayed, and when information was given to them, then they came back both, and they were in touch for last 4 years. And
बताइए क्या बोलना?
मेरा कहना है कि 5 तारीख 5/4 को लड़का बुलाया था, दोनों उनके प्यार मोहब्बत हुई और उसके बाद ये लोग महाराष्ट्र गए हैं। ये सब है।
लड़की का उम्र क्या है?
लड़की को उम्र 17 साल 4 महीने कुछ दिन।
164 में
सेक्शन 90
18-19 साल उसका 183 में।
सर आप साथ-साथ बोलेंगे ना तो लगता है कि कुछ पॉइंट आपके अगेंस्ट रहेंगे।
सेक्शन 90 है, माइनर है और उसका कंसेंट भी है एनी एडवाइस, और द 28 ऑफ द बीएनएस देखते हैं कि बाय मींस ऑफ एनी, वो जो 28 जो पढ़ देते हैं।
नहीं पढ़ने का जरूरत नहीं है, आप हमको ये बताइए, तो इतना प्यार मोहब्बत सबका कहानी बता रही है, इसके बारे में आप क्या बोलोगे?
वो तो एक अदर चीज है, लेकिन जो एज है लड़की की वो लेस देन 18 ही है, उसके राइट टू द प्रेजेंट बीएनएस 28 तो वो उसको देख रहे थे एनी कंसेंट।
भाई उसके लिए आपको तो इस सेक्शन क्यों खोल के करेंगे? कंसेंट ठीक है, कन्विक्शन करा लीजिए। कनेक्शन करा लीजिए, साथ में रह रहे हैं लोग दोनों, साथ में रह रहे
जेल
हैं
में उसे पकड़ा गया उसका कस्टडी उसके बाद
ये नंबर 58 विक्टिम को तो नोटिस हुआ है ना,
हाँ नोटिस हुआ
वो तो नहीं आ रही अपोज करने,
नहीं नोटिस हुआ है
perhaps
she's not
somebody
appearing.
appearing through PC matters
she's not there.
she has not appeared
Who is appearing? Nobody is appearing.
sorry
Or the learned counsel appearing on behalf of the parties. The learned counsel for the petitioner submits that the petitioner is 25 years. Is in custody since
20th 30 अप्रैल 2026
2026. The charge sheet has been submitted.
Yes.
And charge sheet has already been submitted. It submits that the statement of the victim itself reveals that she was in love affair with the petitioner and his parents were trying to get her married with somebody else, and they were trying to negotiate her marriage with somebody else. And she also wanted to commit suicide at one point of time. The learned counsel submits that, as per the statement, the victim and the petitioner have also solemnized marriage, and they were married. The learned counsel for the state has opposed a prayer for bail and has submitted that on the date of the incident she was what age?
17 साल 3 महीने
17 years 3 months.
17 साल 1
17 years 3 months and 2 days old. 5/4 को कितना हुआ था? What is the date of the incident?
date of incident 5-4 months
5/4 is the date of incident.
yes ma'am 5/4/26
5/4/26 डेट ऑफ इंसिडेंट है 1/1/2009 का तो 17
साल
साल
3 महीना से कुछ ज्यादा
3 महीना 4 दिन.
That's and therefore her consent has no value. After hearing the learned counsel for the parties and after going through the statement of the victim recorded under section 183 BLSS, it appears that she had love affair with the victim had love affair with the petitioner, and charge sheet having already been submitted, the petitioner is eligible to be in action.
Item 29B 5805 of 2026.
This petitioner. Counsel for the petitioner seems vacant.
Item 30 BA 5833 of 2026.
Yes. Petitioner.
Item 30.
Who is there? Who is for the petitioner? Argue?
Last officer मांगो jury report मांगा
Our team has simple. Our similarly situated with granted by systems of himself.
Simple injury है क्या?
Only the civil business. Chief Minister.
Let's say it's a direct allegation. This is a very, there are 18 stitches on the vital part of the body. This is it. If let us say C, this is the photograph. This is actually, so the vital part of the body, stone has been hit on the head. This is C, photograph. Mother-in-law, I'm the daughter-in-law. I have also sustained it. Mother-in-law has been sustained. So,
Mother-in-law and daughter-in-law both have sustained injuries. They hit each other.
But mother-in-law, she has, and it has. I am failing to understand how come this injury will be termed as simple injury.
Page 15 you will see the
FIR पढ़ी.
निवेदन पूर्वक करना है कि मैं सुमन देवी पति सोनू कर्माली वो नदी मंगलवार से गिरफ्तार इस वजह विक्रम कर्माली जिससे 45 वर्ष काजल कर्माली ग्रांटेड बेल 35 वर्ष दोनों पिता काली कर्माली
किसको बेल हुआ है? काजल को हुआ है. किसको बेल हुआ है?
काजल कर्माली
अच्छा FIR में बताइए ना किसको बेल हुआ है. काजल को हुआ है और किसको हुआ है? और कालीचरण.
And only was litigation alleged in the FIR. Nobody was the eyewitness in the FIR. It is सब मिलकर पत्थर से मारा. और मेरे पास जो डायरी हम देखें पार्ट 20 में है.
FIR का 2 लाइन पढ़ने के बाद
विक्रम बोला गया उस चारों व्यक्तियों के द्वारा उधारी रज एवं पत्थर से लैस होकर मेरे घर में घुस गए और मेरी सास संबोधन देवी 60 वर्ष को बेरहमी से मार करने लगे. मारपीट करके मेरी सास को बुरी तरह से जख्मी कर दिया और बेहोश होकर जमीन पर गिर पड़ी. तभी मैं वो हमला सुनकर चारों व्यक्तियों को उठने दी तो मुझे भी बेरहमी से मारने लगे, जिससे मैं भी बुरी तरह से जख्मी हो गया और बेहोश होकर जमीन पर गिर पड़ी. तभी उन चारों व्यक्तियों के द्वारा हर जगह मेरी सास संबोधन देवी को पत्थर से कुचलने जा रहे थे कि तभी मेरी धर्मी भैया कुमारी जिसको वहां पर बीच बचाव करने गई तो उससे भी कपड़ा काट दिया. वो जब मेरे से उनको घर पकड़ करने लगे वो उसे दिमाग से बेहोश कर दिया. भैया कुमारी के बेहोश होने पर सोने का चैन पहने हुए थे जिसका कीमत करीब 80,000 रुपये है. वो बेटियों के द्वारा छीन लिया. मुझे और मेरी धर्मी और मेरी सास गंभीर रूप से जख्मी होने के कारण उनके इलाज के लिए गोला उठना पड़ गया और वहाँ पर रेफर कराकर उसे अस्पताल भेज दिया गया. हालत गंभीर देखते हुए रामपुर सदर अस्पताल में आनंद नर्सिंग होम रांची में भर्ती किया गया. ये चारों व्यक्तियों द्वारा हम सभी को धमकी देते हुए जो गोला जमीन का केस किया है उसको वापस ले लो नहीं तो तुम सबों को जान से मार कर घटना पर बिना घटना का इलाज कराने हेतु समय नहीं मिल सका इसलिए आवेदन आज बिना घटना को दिया. Whatever the allegation that is omnibus against all the four persons. Not a specific allegation and a specific one attributed against the person. And it is nowhere mentioned that anybody was the eyewitness. So the
आप कौन है?
हमें विक्रम कर्माली. विक्रम कर्माली.
विक्रम कर्मा.
There is one independent witness has also come in the who says that it was the independent witness Vinod Karmali stated that it was Vikram Karmali who assaulted with the stone on the head of Sita.
Or the learned counsels appearing on behalf of the parties. The learned counsel for the petitioner submits that there is general and omnibus allegation of causing. आप कौन है?
ये गवर्नमेंट की तरफ से.
अब दो जनों को भी सुन सकते हैं जिसके और the learned counsel appearing on behalf of the parties. The learned counsel for the petitioner submits that the petitioner is in custody since 4/5/2026. Charge sheet हो गया? And charge sheet has already been submitted. He submits that as per the allegation in the FIR, there is general and omnibus allegation against all the four persons. and only simple injury has been. ये क्या simple injury है? आप क्या बोलेंगे इसको?
ये देखेंगे भाई लोग इंस्ट्रक्शन ऑर्डर को भी देखेंगे, इसमें लिखा हुआ है 18 स्टिच सिर पे लगा हुआ है। इतना का
Just a moment. इनका तो ये तो simple injury की बात करेंगे ना?
इन ऑर्डर में भी साफ देखा गया है जो दे इंजरी रिपोर्ट अटैच विद द केस रिपोर्ट।
इतना जोर से
इन ऑर्डर में भी ये बात
वॉल्यूम कम करिए। अब हम तो अपना वॉल्यूम कम कर सकते हैं ना? ये मौसम को only simple injury has been caused. The learned counsel for the state and the informant have opposed a prayer for bail and have submitted that there is serious allegation in the FIR itself, which reveals that the mother-in-law aged 60 years, mother-in-law of the informant aged 60 years has been brutally assaulted, and there was as many as 16 stitches on her head. On her head. At this, the counsel for the petitioner has submitted that the co-accused, namely Kajal Karmali, has been enlarged on bail. Where is that bail order?
No, session date order. Date 18.
By the learned sessions. After hearing to this, the counsel for the counsel for the informant has submitted that in paragraph, which paragraph is of the case diary?
It has come in the impute order where the finding is there, but both sides of this case diary.
आपको नहीं पता? केस डायरी का कौन सा पैराग्राफ?
Let's I'm seeing from the impute order. Paragraph 3, 4, 5, 6, and 7.
He has submitted that in the impute order itself, it has been mentioned that it was the petitioner who had assaulted the victim in the present case. And therefore, the bail application of the petitioner was rejected and the bail was granted to Kajal Karmali. After hearing the learned counsel for the parties and after considering the manner in which the offence has been committed, the victim has suffered as many as 18 stitches. Charge sheet has been submitted only against two co-accused, the petitioner and Kajal Karmali. And the case of Kajal Karmali certainly stands on different footing as that of the petitioner. This court is not inclined to enlarge the petitioner in any remains rejected.
Item 31, DA.23.07.2026.
On the last occasion, the leadership state was directed to issue notice to the informant. So,
They are not
FIR is under section 8 and 12 of POCSO Act in addition, and section 137 into bracket 2, 74 and 3 and 5 of DNS judicial.
Let us see the FIR.
Yes, judicial. Page 7.
Yes. Yes. Page 7 is something else.
And it's sure one, it starts from
yes.
page 6 and
You can give just a summary. You just tell me. What is the case?
the leadership
As per the FIR, what is the case?
that the victim was assaulted by this petitioner, and she was tied to a tree, and the petitioner assaulted her, and he touched her here and there, and only this is there in FIR. And in addition, the occurrence took place on 21/4/2025, but FIR has been registered on 26/4/2025. There's delay of 4 days in leadership, and there is nothing on record to suggest that the petition has committed such offense, because in medical examination report also nothing has come as such a leadership, and witnesses have also been examined. Counter affidavit also have been filed by the state, but nothing is suggesting as such a leadership that petitioner has committed such offense. Because what statements witnesses have given, nothing has been brought in record in leadership. There has to be something in the medical report also to suggest that the petitioner has committed such offense. And that too after delay of 4 days, the FIR has been registered.
What do you have to say?
Date of birth of victim girl is 4/2/2010 month. And
Minor.
she is minor. She has specifically stated about the arrest method and
Or the learned counsel separating on behalf of the parties.
medical was done, but ये काफी दिनों के बाद हुआ तो मेडिकल में कुछ आया नहीं.
Or the learned counsel separating on behalf of the parties. The learned counsel for the petitioner submits that as per the FIR, the victim was tied to a tree and was assaulted by the petitioner. She submits that, and also molested. She submits that the date of incident is 21/4/2025, but the FIR has been lodged on 26/4/2025. There is a delay of 4 years in lodging the FIR. The learned counsel has also submitted that the victim was medically examined, but nothing has come with regard to her assault. The learned counsel for the state has opposed the prayer for bail and has submitted that the date of birth of victim was 4/2/2010, and therefore she was just 15 years of age. And the victim herself has lodged the FIR. Could you lodge the FIR? The victim herself has lost the FIR. And so far as the medical is concerned, there has been some delay in medical examination. And therefore the same may not cut much ice. After hearing the learned counsel for the parties and considering the specific allegation against the petitioner made by the victim herself, and as per the impugned order, the victim has supported her statement recorded under section 183 BNSS. This court is not inclined to enlarge the petitioner on bail. It's rejected. However, the stage of the case reveals that out of 7 witnesses, 5 have already been examined. Counsel for the state is directed to ensure that the remaining witnesses are promptly produced before the court. FSN है इसका कुछ? वैसे कुछ भेजे हैं? इसको निकालो. The victim has fully supported the allegation in a statement recorded under section 183 BNSS. उसका कोई उसका केस देखिए 183 का स्टेट के साथ में लगा दीजिए केस डायरी में फाइल ही पूरा लगा दीजिए
Item 32, DA 593/2026.
क्या हुआ है कसरी? We take up the remaining cases post lunch. Post lunch हम लोग का वो एक batch है, okay? कोई बात नहीं, इसको पहले कर लीजिए। 10-12 केस बचे हुए। पास ओवर का कुछ फ्यूचर नहीं आता। आज के दिन में कोई फ्यूचर उसमें डेट पास ओवर जो मांगे उसको सीधा डेट